Hello, good afternoon, everyone, and welcome to Internet Law Review. We are here with the September the 6th hearing, which we now have transcripts for, and so we're going to be covering that. I want to start by thanking Robert Zaz for the suggestion and for the $2. Thank you very much for your contribution. I appreciate it. It's very helpful. It makes me feel validated. And as I mentioned, I'm on a new microphone setup, so hopefully this is a lot clearer. And so I've adjusted all my audio settings, so hopefully that will be good. And we're going to start on page 25 of the hearing, pages 1 through 24, where a lot of preliminary stuff and also a lot of stuff that's very specific under the rules in terms of what things can be attached to what things. But we're going to skip that because the court does. They start by saying, let's just start with the open motions. Let's do something else. I'll deal with the rest later. So if the court wants to deal with it later, so will we. So we'll pick it up with number 25 at page 25 with the motion to dismiss and just read and comment along the way. So let's get started. Ms. Johnson, the motion to dismiss, Your Honor. The court, sure. Who's going first? I'll be going first, Your Honor. Sam Johnson for the defendant. Your Honor, I've done my best in the briefing in this presentation. I know that you're going to hear a lot of the same information from all the defendants, but obviously there's different issues as to each defendant. I'd also point out to the court that this presentation is based on the original response that was filed by the plaintiff. We are here today. My client is a voice actor in anime films and productions. That means she provides the English voice for productions generally that come over from Japan. And I know the court has read these pleadings, so I'm going to spare Your Honor all the nitty-gritty details. You can see the pleadings that specifically relate to my client. So we're here under the anti-SLAPP motion that was filed on her behalf and has two main steps that we need to address. The first is to the burden, and that's how the anti-SLAPP statute should apply. This is to show the plaintiff's legal action is based on or relates to or is in response to Jamie's exercise of either her free speech or her right of association, which are constitutional rights guaranteed to her. The burden then shifts the plaintiff to show by clear and specific evidence a prima facie case for each essential element of his case, each claim he is asserting against her. And we're about to walk through, Your Honor. The statute applies and plaintiff has failed to meet that burden in the responsive documents. So first we're going to talk about the right of freedom of speech. That is a matter that is made in connection with public concern. So we're going to look at that, whether to look at the statements in relation to health or safety, community well-being, or for a public figure. So I really like the way this attorney is starting. Very, very good, very professional. This is the relevant law. Just a very brief summary. The court, you don't want to insult the court by going into too much detail, but you do want to make sure to refresh the court and we're all on the same page. And so this is handled very well in that balance. Just 2-3 quick paragraphs of here is the law, here's the standard, here's what we're going to lay out. Now we're going to start laying it out. Very nice. I like that very much. Now, as to health or safety, community well-being, I want to point the court to these two things. The tweet we see on screen here is the defendant's tweet when she spoke out about what happened to her at plaintiff's hand. The second is her declaration that is attached to our motion. Both make clear that her goal was to communicate to other of plaintiff's victims to let them know that she is there in solidarity with them so that people know how they can remain safe when they're in his presence, and that was her intention when she was writing the statement. The court, are these the only tweets they're suing about? Ms. Johnson, it's kind of hard to tell from their pleadings, Your Honor, but this is only one that actually references the plaintiffs. There are some others. None. They didn't attach a single tweet to the response, Your Honor, so I'm going to base it off the takedown letter that they sent before filing the suit. And I'll provide the court with all 4 of those, even though I think this is the only one that would be in play at this case at all. All right, and the Fort Worth Court of Appeals held in a separate case that when someone talked about an adult that yelled at a kid involving a baseball game, that talking about that person was a statement related to the safety of children in the community. So we're talking about some precedent. There is another case out of Dallas that finds the posts in online forums also satisfy that burden relating to community well-being and safety and health, and those specifically relate to defendant's exercise of her right to freedom of speech. More precedent. Also here, Your Honor, the plaintiff is a public figure. I suspect they might try to oppose that. I think it's going to be tough to do. There are two types of public figures we look at, all right? There's general purpose, which is general fame or notoriety in the community. When we're talking about this plaintiff, who's one of the most ubiquitous voice actors in the anime industry, there's a lot to go on. He's credited with hundreds of productions, including movies, TVs, and video games. He has thousands of convention attendees come to visit him. He's testified that people use his face and name without his involvement even. He has approximately 113,000 Twitter followers at his deposition in June. That's now up to 120,000. And he's also written jingles, as he says, and claims that anyone who lives in Dallas-Fort Worth has likely heard him on the radio. I think that certainly qualifies as a general purpose public figure, but even if not, he is by far a limited purpose public figure as well. That's someone where people are discussing the controversy, third parties feel the impact of the resolution, that the plaintiff has more than a trivial or tangential role, and the alleged definition is germane to the plaintiff's participation. Here, I think the second two are very obvious. I will concur with this attorney. This is what I said also in my earlier review of the summary. I also said that the latter two seem incredibly obvious, and it's the first one that was the contention, so I agree with their counsel here. All the complaint statements center around him, and even if they don't reference him directly. But what's seen here is also to show this is public, that people are discussing it, and that people are impacted, and he's raised, or someone has raised on his behalf, $250,000 GoFundMe war chest for these legal proceedings. I don't particularly like that argument because there are a lot of these GoFundMes and a lot of people contributing to the cause. So I don't necessarily know that shows him to be a public figure, that people are donating to his cause. I think there are a lot of these things where they're not necessarily public figures for that reason. We've had multiple media outlet reports on this, both before and after the first tweet about him. Yeah, public interest is not the same thing as a public matter, right? So just because there's a lot of publicity is not the right standard. He's admitted in his petition that various of the victims' tweets had gone viral, and he even apologized twice on Twitter for the allegations. So everything in this case is centered around the plaintiff. Noosa's testament says there are a lot of non-public figures that have collected a lot on GoFundMe. Yes, I agree. That's exactly my point. You know, there are a lot of people who put forward issues of like, I'm being sued or I'm being slandered, please help me. And people rally around it because of the cause, not because of the person. So I don't think having a well-funded GoFundMe is really indicative of a public figure status. So I agree with that. Next, I'd like to move on to the right of association, Your Honor, which is also a guarantee under the Constitution. And that is to communicate between individuals to join in together to express, promote, pursue, or defend common interest. And I'll again refer the court back to the tweet and declaration excerpt cited to you before, but I also want to point out in the defendant's declaration that was filed with her motion, her clarification is that this is in response to and communication with other plaintiffs' victims, many of whom were coming out on Twitter about what had been done to them. So I think we set up pretty clearly that this statute applies. The anti-SLAPP statute applies. And frankly, I don't know how much time the other parties are going to put into it because it's pretty well established. Okay, fair enough. I think the first element is still a little weak in my opinion, but okay, fine. So then the burden shifts to the plaintiff to provide clear and specific evidence, as we've said, as each element of his claims. So I'm going to walk the court through each of those claims. But first, I want to talk about causation and damages. Those are elements that are common for all of his claims. There are also elements for which he's provided no clear or specific evidence. Well, if it's per se defamation, he doesn't have to. Okay, he's not able to cite a single convention appearance that was specifically canceled due to communication by this defendant. That's a very good point and does prove some of the problems in this in terms of causation. So when you have a lot of people that are saying a lot of things, the question is, what, if any of them, were the other person acting on behalf of? Now, presumably you could get depositions from them as to why they acted certain ways, but it does show a causation problem as to like, what is her portion of the responsibility? So that's a very fair point. The plaintiff is not aware of any contact between this defendant and any of the convention runners. He's unable to state a specific amount of damages, even when given 2 opportunities to file a declaration with the court. That should be relatively easy. I mean, he should be able to give a reasonable estimate for the damages from being not invited to those conventions, because he's attended a lot of these things before, but whatever. His effort is an assumption looking at other conventions that he's attended for the year. Well, that's a reasonable basis, in my mind. If you're looking at other things that you've done and said, well, this is a reasonable thing to anchor it against, that seems reasonable. It's how we value a lot of things. There doesn't appear to be from his deposition testimony even a drop of his rate of conventions in attending this year. Well, he wasn't able to attend certain conventions, so that would definitely be a drop. The court. So you're telling me there's not an affidavit from some convention saying they didn't hire him because of the tweets? Ms. Johnson, that's correct, Your Honor. Yeah, that seems like you would definitely want to get affidavits or depositions or other things from the people who are running the various conventions he was not invited to or disinvited to. You'd want to get them and say why they acted certain ways and whether they were aware of particular tweets and whether they acted on the basis of those tweets. You'd want to ask for like internal emails or internal deliberations that might reference them. So you'd want to get some of that from those third parties. So they apparently didn't attach that. So that's odd to me. Ms. Johnson, that's correct, Your Answer. The court, anything else would be speculation. Ms. Johnson, Mr. Johnson, yes, there's plenty of speculation and hearsay. The court, okay. Mr. Johnson, even that, though, Your Honor, it's not specific to her, all right? Everything is hearsay from unnamed people that generally conflict with the defendants. That's all they have to go on. Now, if you look at the case law from the Texas Supreme Court on what the clear and specific burden is, clear means the evidence must be unambiguous, sure, free from doubt. Specific means it must be explicit. Neither appear anywhere in regards to the causation or damages in this record, particularly as to this defendant. Someone asks, are you correct in assuming that defamation in the U.S. is a purely civil matter? I'm going to say yes, because I'm hard-pressed to think of where it would be a criminal matter in terms of defamation. Unless you were like, the only way it could come up, I suppose, if it was part of some instigation. So if you were like, trying to, inflame a mob and said defamatory things and that caused them to act, that would be, but then you're still being charged with the incitement, not the defamation. So I think defamation is probably safe to say that's purely civil. Yes. Okay, real quick, Your Honor, I want to walk through defamation. There are, like I said, 4 statements. I think the court is aware of the elements of defamation. I want to point out that there were no statements by Jamie that were attached to their response. Okay, here's one of the tweets from the takedown layer. This is not not in their response. It doesn't refer to plaintiff. It doesn't defame him, and did not have anything to show it was made with malice. Obviously, there's some strong feelings involved, but the standard for malice is more than just showing someone is very upset. Very true. Malice has nothing to do with whether someone's upset or not. It has to do with whether someone is in reckless disregard of the truth. It has to do with ignorance of facts, not someone's subjective motive. The next statement that was in their takedown letter is right here, also not in their response. No reference to the plaintiff and no false statement of fact. Nothing to show there was malice. Again, some strong feelings, but that's not the legal standard. True. Here's the next one, Your Honor. Again, not attached to their response, no false statement of fact. There's a quick reference to the plaintiff by his first name, but it's not a defamatory statement either. And finally, we have the defendant's statement that we looked at before. I'll give the court a moment. I see Your Honor's reading it. Okay, I've read it. So what we're lacking here is that there's a false statement of fact that is defamatory to the plaintiff that was done with malice. They don't refute it in their response. They don't have any evidence, credible evidence. What they do have, Your Honor, is one sentence by the plaintiff that says, I never grabbed her hair and pulled her down, which directly contradicts his deposition testimony, where I asked if the defendant wasn't the first woman whose hair he pulled. He said, no, we established that. We'd have to go to the deposition to see exactly how that's phrased, and the deposition's like 500 pages, so we're not going to do that. When asked if it was possible that the defendant perceived pain when he pulled her hair in the lobby that day, he said, I had no indication when it happened. So he does take issue with the term pulled hair down, but as you can see, even motioned for the camera, what he did, he yanked her hair, took control of her head and body. Very quickly, Your Honor, there's also claims for tortious interference, very similar elements there. I'd love to say there's some evidence for me to fight with, but there's nothing. No contracts, no relationships, and no manner of inferences that's cited specifically as the defendant. Very fair point. Someone else pointed out in a response to the earlier stream that Texas is a notice pleading state. That's true under the federal rules as well. So both in federal court and in Texas state court, you only have to make notice pleadings. You just have to make someone aware of what you're doing. But as things go on, you have to be more specific because you have to give them exactly what you're saying. And so they're saying here, look, I don't know about any contracts. I don't know about any relationships. I don't know about anything because I haven't been told anything. So, by this stage of the proceedings, I have to have a little bit more so that I can defend. There's nothing here for me to work with. So that's a very fair point by this lawyer. Very well done. Similarly, with civil conspiracy, there's no evidence whatsoever of a combination of two or more persons, the meeting of the mind. The court, is there a plan? Mr. Johnson, no plan. Not even nothing, Your Honor. I'd love to be able to guess at what it is, but there's nothing there at all. So we go back and look at clear and specific. That was their burden and they failed to meet it. The only thing that's clear and specific as the defendant, Your Honor, is the claims against them that need to be dismissed. Okay, so that makes a lot of sense. So basically in their initial pleading, they said, we're making these generalized allegations. There was this response under the anti-SLAPP provisions. This has a two-part standard and there's a burden shifting. And so they're basically saying, look, yes, you initially didn't have to make a specific complaint. But at this point, we have shown this element, and so you're on the burden to show us, and you haven't. So that seems right on the law. The court, let me ask you this. How do I deal with the element of defamation with regards to whether it's false or not? I don't know that it was ever provable one way or another until they decide. So what's my standard when ruling with that? Well, Your Honor has to look at the evidence that's before the court and determine if it's credible. I think there's a lot to indicate that's not credible. We've got the fact that burden is clear and specific evidence. It's got to be more than just surmise. Well, to answer the court's question, the way that you answer the truthfulness is essentially, unless it is readily apparent that it's false, you assume it to be true because we're on a motion to dismiss. So we have to assume that everything the plaintiff says is true. Now, we don't have to be idiots about it. So if it's clear that it's false, we can reach that conclusion. But the presumption is that everything is true because we haven't had any testimony yet. So on the legal standard, we just assume that everything is true. Mr. Johnson, there's nothing defamatory here, Your Honor. She said that he pulled her hair, that he whispered something to her, that she thinks it was sexual. She can't specifically recall. There's nothing defamatory about that. The court, is it not a fact question whether it's defamatory or not? What may be defamatory to you may not be to others. Mr. Johnson, I don't think that's a fact question that needs to go to the jury, Your Honor. I believe the court can determine the court needs to look at the context of the statements in order to make any determinations as to that, and it's not been proved in their response. It's still their burden to put forth clear and specific evidence. Okay, so the court is giving them some challenge and they're responding in a reasonable way. Okay, do y'all want to go with each defendant? Mr. Beard, okay, the court, let's do that. So he's asking, do you want to do one defendant at a time? Yep, and he says, yes, I do, which is perfectly reasonable because, every defendant and every cause of action is independent, so perfectly reasonable to do them independently. Jason Firth says, did this happen? Seems like a fact question. It is a fact question. The question is, someone saying X happened is an issue of fact. So if the plaintiff says, no, this didn't happen, and the defendant says it did happen, there's a conflict. But what we've read so far in the proceedings is that according to the defense lawyer, the plaintiff, although they said, no, it didn't happen, in their deposition, they said, well, it did happen. So there's no factual dispute because their pleadings are inconsistent with their deposition. And so they're saying, look, they said under oath, because depositions are taken under oath, they said under oath that this hair pulling incident happened. That's the way I'm broadly reading this. And so they're saying, look, there's no actual genuine conflict of facts. Both sides agree that this factually occurred. So that's what I'm seeing so far. Mr. Beard, Your Honor, we have a notebook that we've already been providing to opposing counsel, but I think the court, okay, I have all that stuff. If it's in the pleadings, I have it. Mr. Beard, this just exhibits and stuff. It's part of the pleadings. The court, I have all that. I'm good. Mr. Beard, well, right out of the court, tell me what actual statements you're saying that the defendant said that were defamatory about your client. I mean, he showed 2 tweets. Mr. Beard, okay, let's see. The court, the ones that are in your pleadings. I mean, there may be more, but the ones you actually have used. Mr. Beard, are we including the Second Amendment pleadings or not? The court, okay, I don't think so. Mr. Beard, okay, let me go back then if I could. While I'm waiting for this to come up, Your Honor, we are alleging conspiracy as well as defamation. The court, well, let's do defamation first. Perfectly reasonable. Let's break them down into their individual parts. Sure. Mr. Beard, okay. The court, and for her specifically, also very reasonable. We're going to look to each defendant specifically. No problem. Mr. Beard, so I want to remind the court, if I may, that we're talking about prima facie evidence. The court says, I'm just asking you how many tweets there are. Mr. Beard, well, I'm trying to coordinate with that with what we got our First Amendment petition, so give me a second, if I may. There's a tweet in which she referred to the plaintiff as, I'm trying to find it here, he's a monster. I give no shits if they're harassing Vic. He's a monster. Look around. There are dozens and dozens and dozens of report. If you don't see it, it's because you don't want to. It's true. So the only factual statement in there would be like the dozens and dozens and dozens of reports statement. Everything else seems to be opinion, at least to my mind. They're talking about sexual assault allegations when there are no crimes reported. There were no investigations, and most of these so-called accounts did not materialize. The court, that's 1 tweet. Mr. Beard, that's 1. She also set up what's called a Discord server. We know Discord. A Discord server is private. The court, I'm just asking how many tweets there are. Is it 1? Uh-oh. You're in a bit of trouble now because the court just asked the same question 3 times. So basically, this is where you snap to it and just make sure that you're answering what's actually being asked. Mr. Beard, it's several. I'm trying to. Reading. I want his head. I want his balls. I want to feel. The court, I saw that 1. So that's 2. Okay, you saw that 1. The court, you're standing up. Yes, Your Honor. Okay. Did you? I believe the court asked him about what was in the amended petition, not the Second Amended. Incidentally, in the first 25 pages, the reason they mark about the standing up, one of the lawyers apparently had some sort of illness and caused her to be having to sit down. And the court gave him permission to all sit down. So the court's just noting that he's standing up because he doesn't have to. Normally you'd have to stand up, but they asked for permission to sit, and the court gave permission. So in case you wanted to know, that was in the first 25 pages. Mr. Johnson, did you? I believe the court asked what was in the amended petition, not the Second Amendment. The court, yes. The amended, correct? The court, right. The only one in that petition, Your Honor, is I want his head. The court, he needs a copy of it. He's referring to opposing counsel. Do you have one? Mr. Johnson, I don't have a paper copy of the amended petition, Your Honor. I apologize. Well, you should have a copy with you in paper or otherwise, because you might have to refer back to them. And lawyers bring in these mounds of books and stuff, so you probably should have it with you, but whatever. The court, and I'll tell you, as far as the Second Amendment petition is, I don't think I can consider it because we would never have a hearing like this because you always file a petition right before, a new petition right before, and would void everything that was filed before it. It's not fair to them to file their motion to dismiss for you not to file a proper response to it. And then you come in and amend your petition, which may nullify their motion to dismiss. At some point in time, we have to have a motion to dismiss hearing. And you can't just keep repleading to get around it, because that's what you're doing, is you're repleading bad stuff to get around the motion to dismiss when it's obvious you thought your first petition was deficient. So again, this goes to issues of when can you amend your petition? When can't you? At what stages? You do want to try to get it right the first time. You sometimes can amend and sometimes not. And eventually the court's going to say, look, you're just stuck with what you have. Probably not the first time, but there's going to come a time when they're like, yeah, we're done now. Time to go to trial, right? Or hearing. Mr. Beard, in this case, Your Honor, may I ask for a trial amendment to replace those defective affidavits with unsworn declarations that are identical, and declarations that are allowed to suffice as affidavits, and I can explain that. Mr. Limon, we're opposed for a couple reasons. The court, go ahead. So he's got affidavits that were attached to the response. Is that correct? Mr. Limon, that's correct. The court, and then you've withdrawn those because there was an issue with the notary. Yes. What was the issue with the notary? Mr. Beard, I was the notary, and I thought I could notarize based on a telephone call, knowing the affidavit, and turned out to be wrong. You probably should know the standards in your relevant jurisdiction for what you can and cannot notarize and how. Just saying, if you're going to be a notary and sign legal papers, you probably should know what the standards are. Mr. Limon, it's not just wrong, it's contradictory to what the statements in the affidavit are, which is subscribed and sworn before me today. And there's specific mobile notary provision that's in the notary statute. This would be a thing that, like, for example, a lawyer might want to consult, or a notary might want to consult. And if you're one the same, you might want to consult it twice. I think you have to take a different course, and then you have them on Skype, and you can watch them sign it, and then you can notarize it. He didn't do any of that. Okay, well, if they're standards, follow them, right? And then I'll give credit to Miss Valeni, because I wanted to wait until we got here to make the argument, but Mr. Valeni said, no, maybe you're mistaken. Give Mr. Beard the opportunity to explain it. We sent over an email and said, please explain it because it looks bad. It looks like your people said you were in front of you, 1 in Odessa and 2 in Fort Worth. Please explain it. No explanation for 39 hours. Not super encouraging. The court, okay. Mr. Limon, and then the second amended petition comes out with declarations and he says no fraud. There was a defect in the form. Okay, fair. Those are different standards. Like, there's a difference between fraud and like a defect in form. So that's a reasonable argument. Whether it's true or not is a whole other issue. The court, okay. Mr. Beard, may I respond, Your Honor? The court, yeah, I mean, I'll probably consider the affidavits as far as your response, but not your new pleading, not your second amended petition. That's obviously you're trying to get around the rules. I mean, I've read them, so I know what they say. It's going to be hard for me to put them out of my mind now that I've read them anyway. Yes, Your Honor. You didn't get an accurate copy of the email. I'm not worried about that. I'm worried about the cause of action. So basically he's saying, I don't really care about the notary issue right at this moment. Fraud would have to be on purpose, wouldn't it? Probably. I mean, it would have to, there is usually an intent of fraud behind it. But it would depend on how it's written specifically in the statutes. I'm worried about the cause of action that you have against the defendant and the tweets that are in your first amended petition, because the petition that we've heard about, because you didn't file a second amendment petition till after you did the affidavits wrong. So let's deal with that one and tell me what the tweets are than the two you told me so far. What are the tweets? What are you suing over? Yeah, that's a good question. Mr. Beard, I have to beg the indulgence of the court for just a second because I got to find the document. So there's actually 2 documents that are operative, I think, Your Honor. Our response, the court, yes. And our first amended, the court, yes. Okay, Jamie tweeted. We quoted a tweet of February the 9th where she said that they have, quote, done this exact same thing to half a dozen other women I personally know of, and he's a predator. Now a tweet on February the 9th of 19. That was one. She also stated in another tweet that she wanted to name and shame him. She participated in a Discord server, which is sort of like a tweet. Well, okay. And it's a private forum that was dedicated to ruining Vic. The only reason that we ever knew about it was one of the participants in the Discord rolled over and started producing the posts. But of course, we don't have the contents of the posts. We just have the titles of some of them. But the Discord server is pretty strong evidence that she was part of a conspiracy to ruin the guy. Well, as to the conspiracy, perhaps. But we're not talking about the conspiracy at this exact moment. We're talking about the defamation. So let's keep track of what we're talking about. One thing at a time. We're talking about the defamation. We can get to conspiracy later. But we're doing this one thing at a time. So don't talk about other issues. It's not relevant to what we're talking about at this moment. What this case is about, Your Honor, honestly, is these folks accused him of sexual assault for years and years back. The defendant's great sexual assault that she claims that he did, that he claimed that he grabbed her by the hair, pulled down violently, whispered something sexual. She can't establish when it happened, where it happened, or what he said. She, along with others, Rial, said that they ate the jelly bean and sexually assaulted her. Then they went after the conventions. We have Rial and Toe, for example, actually interfering with contract. Now suddenly you're trying to talk about tortious interference. That's not the issue. The issue at this precise moment is the defamation. So let's stick to that. And the court says, let's stick to the limited subject of publications. Sure, that she has made. Let's stick to the actual tweets. Let's stick to what she's done. Right. So right there, I mean, those statements are defamation per se. They're accusing him of sexual misconduct. I'm sorry I got sidetracked. I'll see if there's other. Let's see. They're in a response. In our amended petition, let's see. Okay, that's all I can find these documents at the moment. But again, those statements alone, her participation in the Discord server, prima facie evidence. Well, first of all, it's defamation per se. It's absolutely valid to draw a rational inference that she's got malice towards him because the court, does she use his name in those tweets? Mr. Beard, yes. The court, okay. Mr. Beard, yes. Well, the court said, you said yes. Mr. Beard said, I want to correct that. Not super sharp. Don't try to mislead the court. Not a great idea. The context of those tweets, they're talking about him. I don't know that. The court, where in the context that, can you see that? I mean, do I need to see that, or do I just take it that you're giving the evidence? Mr. Beard, well, I can show it. The court, well, that's kind of what I'm asking for. Mr. Beard, I'm sorry. The court, that's what I'm asking for. Mr. Beard, I can only show it right out of our Second Amendment petition. The court, well, sorry, you should have done that before. So there's an issue of the timeliness of certain things in between one petition and another. Mr. Beard, right. Court, so I'd like to know the context. So she's talking about somebody, and you didn't even provide the context it was, because she just said this stuff about a person. We assume it's him, but we'd like it to be easy to prove. It felt like, but it didn't. Mr. Beard, defense counsel did mention that the tweets were about Vic. The court, I understand. He's not giving evidence either. None of you are on the stand. Very fair point. The opposing lawyer is not a witness, right? I think what he said was the only ones you're claiming about the plaintiff is that one. Mr. Beard, sorry, Judge, I didn't hear you. The court, okay, what was your response to the one filed on the 3rd? Mr. Beard, our response was, according to Rule 11 agreement, need to be filed on the 30th. We had every intention of also filing an amended petition because, again, that's what you told us to do. Honestly, that's not part of the Rule 11 agreement from our side. The court, your response was filed on the 3rd, too. Is that just because of the Mr. Beard? No, Judge, it's not. The court, is it just because it came in on Monday because of the holiday? Probably, okay. Mr. Beard, no, what happened was it was due midnight on the 30th. The court, right. Mr. Beard, we had technical problems and got in like 15 minutes late, and we can prove up the technical problems. Just as a practice tip, you want to be careful about this because sometimes courts will like bring down the hammer if they're really irritated with you. I saw this once happen in a Fourth Circuit Court of Appeals case where this kind of thing happened, where there was technical problems and the guy filed 15 minutes late. And because the court was already really irritated with him for other reasons, they refused to enter it because it was 15 minutes late and they dismissed the entire case. So you do want to be careful when playing with these time frames because every once in a while the court will stick to the letter of the rules and they will really burn you. So just FYI, that can go really wrong. The court, and it also goes the next day. Is that how it works? Okay. Mr. Beard, yes, sir. This is all over the Labor Day weekend. The court, yes. Mr. Beard, so we file on the 30th, basically 1 in the morning or 12:15 in the morning or whatever, when we finally got through the portal on the 31st. I left town, went to Denton. I can prove that. I was at a convention, didn't check email. The court, that's fine. I'm not worried about it. Mr. Beard, Monday morning, I came in. The court, again, I'm not worried about it. Yeah, when he says I'm not worried about it, move on. Mr. Beard, but I mean, we're always intending to file the amended petition with everything attached. It wasn't. If I had known that our amended petition was required by the Rule 11 agreement, we would have gotten it in. It was really simple. Just, reshuffle the information is already there. It added some exhibits and stuff. That's true. But again, we're allowed to. I always thought we're allowed to amend the pleadings. The court, yeah, I mean, how soon? Can you amend the day of trial without leave? Mr. Beard, not a trial, but this isn't a trial. This is a hearing. True, but that's kind of the court's using them interchangeably, and in the context of what we're talking about, one is substituting one for the other. So that's not really a pointful correction. I would use them interchangeably. In the context, it doesn't matter because we're not talking about something where it would matter whether we're at a hearing or trial. There's no difference in terms of how we'd be practicing this in terms of the legal implications. So you can just use one or the other. Anyways, carrying on. The court, well, this could dismiss your case. At some point, you've got to stop amending pleadings so you actually file a motion to dismiss. And it has to happen at some point, doesn't it? Mr. Beard, I think it does, but if they could claim that they were surprised, I would suppose so. But they're not surprised. We've been wrangling about this. The court, well, I think they're surprised more about the contents of your petition than the affidavits. You actually have more complaints in your petition than you did in the other one. Your Honor, is that not true? Well, you have to ask them. I'm asking you. No, I don't think that's true at all. Okay, so they're the exact same petition, the First Amendment and Second Amendment, except there are. Mr. Beard, there are some exhibits that actually show the emails rather than quote them. That's the main difference. We did put some unsworn declarations because of time we put them together. We were aware the affidavits had a problem. Your Honor, amended pleadings are routinely used to defeat summary judgment and dismissal hearings. The court, they won't defeat a summary judgment. Amended pleadings will not defeat a summary judgment. You can allege a new cause of action or you can remove a cause of action, but you've got a cause of action within your pleading. A summary judgment requires a response with evidence. Right. It's not your pleading that's going to support the motion judgment standard. Right, Your Honor. But the difference here is the action where the pleadings. You brought up the summary judgment. You don't need to tell me the difference. I didn't bring it up. Well, I'm trying to analogize, I guess. The court, okay. Mr. Beard, what I'm saying is it's routine to amend pleadings before trial outside of not within 7 days without permission. This is a hearing. There's no reason to assume we're under any particular burden. We got in as quick as we could. The court, let me ask you this. So if you're always intending to file a second amended, why'd you wait until September the 2nd to get them to sign those unsworn declarations? Mr. Beard, because I found out what would have happened is the defective affidavits would have gone into, but we found out about it. Opposing counsel notified us. I checked into it, and we want so that's why we did what we did. Okay, point me to evidence that says the statement by this defendant related to or referred to the plaintiff. I want to see his name in something that you filed with regards to that. Mr. Beard, at this time, I don't think I can tell you anything more, and we already did. Okay, so then that count is dismissed. All right, perfectly reasonable, right? He doesn't have, what he needs. And so, motion to dismiss on that particular standard. Makes sense. Okay, so that one is dismissed. All right, conspiracy. Do you have evidence of a plan? We do, Your Honor. If I may approach. I don't need it. Is it on file somewhere? No, it's just an exhibit to show our brief chart. I don't need that. Just tell me where the evidence is that these people got together and made a plan. That's what you need, right, for a conspiracy. You need 2 or more people to get together to agree upon a course of action, and one act in furtherance of that course of action. Mr. Beard, okay, the Texas Supreme Court has held conspiracies are provable by implication and circumstantial evidence. Rarely do conspiracies say we're involved. These defendants, that's conspiracy number 1. And remember, we're talking about rational inferences, minimum quantum information necessary for rational inferences. Monica said in her deposition that she and Jamie had been friends for a long time. In our First Amendment petition, I believe page 5, we know that she liked and retweeted same or similar information, calling Vic out and calling the conventions to drop him. She founded and participated in an anti-Vic support group. I think that's the name of the group. I think it's reasonable to infer that's a conspiracy right there to destroy the guy. Yeah, not bad. She attacked those who questioned the accusation. We're talking about rational inferences here. That's a conspiracy combination. And again, from the prima facie evidence, the minimum quantum of evidence necessary to support a rational inference. Not reasonable. Yeah, fair enough. The court. So basically, 2 people that agree on a comment to a news article are in conspiracy with respect to their comments. Mr. Beard, at a prima facie level, I believe so, Your Honor, but there's other context. The court, but I'm just saying I post on some article about something in the New York Times and someone else agrees with my comment. We're now in a conspiracy? That's a very fair point. To have a conspiracy, you have to have 2 or more people who are agreeing together. So if I like your tweet, that isn't you liking me back. So that's a very fair point. There's not mutuality. Mr. Beard, if you're both attacking the same person, I'd say you are. I mean, conspiracy might be. It depends on what you say, obviously. The court, that doesn't make any sense. I tend to agree with the court. Mr. Beard, well, I could try this. The court, yes. Mr. Beard, sure. The court, sure. Oh, Mr. Beard, okay. Let's say that I say that Vic is a sexual predator. Now, that's a defamatory statement. It's defamation per se. And Lee likes that comment and retweets it, puts it out there. And when you retweet that, you're implicitly saying, I agree with that. Well, that's an issue of defamation at best. It's an issue of republication. It doesn't show conspiracy because there's not mutuality. In addition, Ann Lee on his own says that Vic is a sexual predator, and Ann Lee got involved in trying to get him canceled from a convention, of which we've got absolute clear evidence of that, which would go to an issue of tortious interference. So yes, I'd say those facts is a rational inference. It's a fair rational inference that Ann Lee and I, in this hypothetical, are in a conspiracy. In addition, you have Jamie saying in a tweet that her higher up at Funimation was her husband. Now, rational inference. And that's part of the problem we're talking about this piecemeal. Well, you said, let's do it piecemeal. You agreed. I read it earlier when you said, let's do it piecemeal. So, just saying. Now that we're doing it piecemeal, you can't complain about that. You said okay. That's part of the problem with taking this piecemeal, Your Honor. We've got 4 moving parts here. We've got 3 or 4. We've got Rial, Toei, Mariachi, and Funimation. We're alleging they all defamed him. We're alleging they all conspired to defame him. We're alleging they don't have to allege this. We got proof of this, that they interfered with his appearance at conventions. We're alleging Funimation, essentially, these people were Funimation is liable for vicarious liability as well as their own actions. Vicarious liability for the actions of their employees. So it's kind of hard to segregate Maharashi in one little slice. But you said that they should. I mean, I could go back and reread it, but we already read that. So let's ignore. It is with due respect, might be better to go through all defendants and then let us respond, because it's not a very helpful kind of thing. I know it's not very helpful. Your Honor, I talked to Mr. Villani. We can let them, but it's obviously up to the court. Yeah, so the court, I don't necessarily care. It's just kind of easy for me to categorize them for what I do, the first individual, and examine what they did as opposed to everyone in the whole. And again, on slander, as someone republishes a statement that you published, they're on the hook for that slander also, but it doesn't mean they're in a conspiracy. Yeah, that's exactly what I just said. So if I retweet, that might be republication. Therefore, it might be slander. It might be libel. It might be defamation, but it's not conspiracy, because conspiracy requires an agreement, and there's no agreement. If I simply like your tweet, we don't have an agreement, because all we have is one way at best. So no conspiracy. The court's 100% right. No, that's not the only evidence we have, but, Your Honor, it's rational to infer there's conspiracy. The court, I mean, people post pictures of their cats on Facebook, and I like them, I hit like. I'm not in a conspiracy with that person because I like their cat photo. Silly example, but correct. The court, I'm not even saying that I like cats. I'm just saying I liked your picture, and it's not a conspiracy. True that, too. Mr. Beard, I agree, Your Honor, but here's the thing. There's no such thing as a tort for posting cat photos. Well, there might be, but yeah, never mind. I mean, anyways, the court, well, I understand that. What if we made a statement the Cowboys didn't do that play right, and I like it? I'm not in a conspiracy to disparage the Cowboys. I just agreed with that. I don't know what she's thinking, but I don't know what they call the right play either. But I don't hate the Cowboys. I mean, that's the problem. I think you're reading too much by liking a post. I don't think that makes you a conspirator. I would tend to think so too. I don't think merely liking a post is enough. While participating in Discord servers that is explicitly designed to attack him is. That sounds a lot more plausible to me. And, as I said, opposing counsel in the discussion said that he was talking about Vic and those. He said you were alleging that you were talking about Vic. Yes, that's your allegation, and I understand it. That's my allegation. And what he said was that's your allegation. And he actually pointed out that your name is not in there. He didn't. I assume you weren't stipulating that was about him, are you? No, Your Honor. Okay, he wasn't stipulating that. Can we take a 5-minute recess, Your Honor? Co-counsel has called my attention to something. So they take a 5-minute recess. Not going off so well so far for Vic. When we read the initial argument from defendant's lawyer, it was nicely organized, well presented, very sort of good summary of the law, very crisp. And the court is having to ask Vic's lawyer like the same question 2, 3, 4 times. The court's saying, I want to talk about this, and Vic's lawyer is talking about things that are not that. He's going off on other things. And then he's complaining about the fact that it's piecemeal, even though he agreed to it. And he doesn't seem to have clear answers to a lot of these questions. So it's not like he seems a little disconnected to my mind, as opposed to the lawyers for the defendant, who so far seem a lot sharper on balance. Okay. Recess over. The court. Okay, where are we? Mr. Beard, I think that the information the court asked for, and actually in the motion to dismiss, I can use this device or I can read it for you. What page? That's a good question. The page is not numbered. It looks like page 39 of the electronic file. The court, okay. 38, 39. Okay, what does it say? Go ahead. I'm sorry. So let's see, 38. I want what's in his head. Comments said, I'm really surprised he leaned so hard on the tweets instead of the Discord. That would have been a way stronger lead. I agree. Especially for especially for the defamation stuff. I would not, I personally take a bit of I'm not even sure that merely retweeting is enough for republication. I don't know what the issues at law are, but that seems a little thin. But yeah, I'd go with the Discord. Right. So she posted 4 in one tweet. It appears on page 39 of their documents. She posted 4 pictures. That's a way to get around the character limit on Twitter if you write up a screenshot of that. And so on the second page, she's talking through her, various complaints and accusations with Vic. And she says because he was the only one in Vic, and she's accusing him of simple assault, of assaulting half a dozen other women she personally knows, women unable to get out of his grasp, and on and on and on. That's what Jesus would do, light him on fire and send him to hell. The court, are we still arguing defamation? Yes, you are. And the court just dismissed this 4 pages ago. So why are you talking about this? That's not the question. We moved on to other things. The court, are you going back to that after I ruled on that? Are you arguing conspiracy? I thought we were on conspiracy. We are. Mr. Beard, I'm sorry, Your Honor. I apologize. Okay, we're not doing conspiracy. We were. I backed up. I apologize. The court, let's do conspiracy. Okay. I mean, if your definition of conspiracy is I signed a petition to get someone fired for doing something, that's a conspiracy. We're all co-conspirators on a petition. No, Your Honor. So if I get on a website, a blog, and I complain about the police chief, I think he ought to be fired, and other people do that. We're all in a conspiracy? Mr. Beard, where's the tort, I mean? Well, whether or not there is a tort is sort of irrelevant to the idea of a conspiracy. There's a very famous law blog, I highly recommend it, it's very good, called the Vala Conspiracy. And they named themselves as this tongue-in-cheek because there's a whole bunch of law professors, and they're in a conspiracy to do lawful things, but they're still in a conspiracy, right? And so is every business in the history of time is in a conspiracy. It's two or more people in an agreement to do a thing and furtherance of the thing. Now, the fact is the thing they're doing is lawful, so the conspiracy is lawful, but the conspiracy can be separated from the tort. So this question, where's the tort, doesn't quite follow, because whether there's a tort or not is kind of separable from the idea of the conspiracy to commit the tort. Conspiracy is separate from the tort. It's not super complicated. If I'm trying to get him fired, I'd agree. Trying to tortiously interfere with his existing conscience, that's a tort. That's stipulated in the hypothetical. What you're saying, we haven't gotten that part, Your Honor. I'm trying to figure out where your conspiracy is. What's the cause of action the conspiracy is related to? The tweet. What cause of action is your conspiracy related to? Oh, I got you. I'm sorry. Defamation, tortious interference. Part of the problem here, Your Honor, if I can. All under common law, members of the conspiracy all have the torts committed imputive. That's true as a matter of law. Anyone in the conspiracy is guilty for everything anyone does in the conspiracy. So sure. The court says sure. Mr. Beard, right. So you're asking me a mousetrapping question in the sense that you're asking me to say specifically what she did. She defamed him. I mean, that's a particular thing. She defamed him. But she had to be involved in a conspiracy with other people. Right. And so my question to you is all the causes of action, and these people all got together and had a plan to interfere. Do they have the power to do that? Yes, they do. Okay, we have evidence of that. Marchi does not, or at least we don't have evidence of it yet. We have Raw and Toy in the affidavit, the unsworn affidavit. We have proof that they did. Text messages saying he's a predator. You aren't proving a conspiracy. You aren't proving agreement. I don't understand this argument. Marchi did not, and you didn't have a conspiracy to get together and plan to get fired, right, Your Honor? But we're not required to prove that she's directly involved in each tort committed by the conspiracy as a whole. That's imputed to her jointly and severally. The court says that's not true. I mean, you have to have a plan to commit the tort. You have to have a plan to commit the crime. And of course, there's other crimes that happen or torts that happens. I think it could be liable for those. Yeah, you have to have a conspiracy to do the thing. And other things might be imputed too. So the court's right. I'm trying to figure out where Marchi has a plan, whether her plan stems from more than just trying to speak on something of public concern. She personally wanted to get him fired, but that does not mean she's working with the others. Right. There's no conspiracy. You have to show agreement. Just because they're all doing the same thing, you have to show agreement. And the Discord seems like pretty good evidence of that, so I don't know why we're not arguing about that. If she's accusing him of making him, she's committed defamation per se. I mean, everyone on the list should be here. We don't know who they are because we can't engage in discovery. The court, but you think they were all involved in conspiracy. Well, I mean, the name of the Discord sort of implies it, doesn't it? Mr. Johnson, Your Honor, that does not even in the record. The Discord's not in the record? Is that what Mr. Johnson's saying? The Discord is not in the record? If that's true, if it's not on the record, then you have a massive evidentiary problem. You have to put it in the record. Both sides have to be aware. We don't do trial by ambush anymore. You have to let the other side know what you're complaining about. So if the Discord is not in the record, then you've got a massive evidentiary problem. And I don't know why it's not on the record. That seems odd to me, but we are where we are. The court, I know it's not. And I think he's just reaching. I really do, because I can't sue everyone that says bad stuff about me. They just do. But Your Honor, this is not just bad stuff. This is defamation of law per se. When you accuse someone of sexual assault, which is what she did, that's defamation. We're going back to defamation. We've already dealt with the defamation issue. It's over. It's over. We're talking about the conspiracy. Where's the conspiracy? Where's the agreement? Anyways, The court, show me proof of the conspiracy. That's all I need. Where's the concert? Just because two people have the same opinion on something doesn't mean they're working together. Right. Well, she's replying and saying that she has higher up in Funimation response to the tweet talking about all this. Again, she went back. We're back to. She testified that she and Marchi were very good friends. They made identical allegations. They both claimed they grabbed her hair, yanked her down, and that was assault. And that was resulted in the guy getting fired from 2 studios and disinvited from a dozen conventions. It's not a case of, a couple of my celebrities getting a snit. This is real stuff. Well, not. I would think it's my celebrities getting a snit, but whatever. I have to go back to defense actions and activities. You still have to prove a link between them, other than they're friends and they work in the same industry. Yeah, no shit. It's like, where's the conspiracy? Where's the agreement? Where's the agreement? Show me something. Show me a conversation. Show me anything where they made an agreement amongst themselves. And if it was the Discord, that probably should be in the record. And if it's not, well, that's a real problem for you. It's not a problem for the court or the defendant. That's for damn sure. Other defendants may have issues and they may not get theirs dismissed. I just don't see a conspiracy because you don't have a plan. Right. Your Honor, we're not trying the case here. We need prima facie evidence. Like what? I don't think it's rational that someone posts and someone likes the post. I don't think that means you're in a conspiracy. I agree with the court. It's not a conspiracy because there's not mutuality. If they retweet, I don't think so. Again, no mutuality. No, I think they may be responsible for the tort of retweeting it, but they're not in a conspiracy. Right. That's what I was saying. If you retweet, that might be republication. It might be defamation. It's not conspiracy because there's not mutuality. There's no agreement. They may be responsible for the tort of retweeting it. Is it rational to infer their might be. Court, no. I mean, our president retweets stuff all the time. He's not in a conspiracy with someone he retweets. Well, the court, is he? Mr. Beard, well, the president is not being accused here. Well, you were analogizing earlier, so don't get salty when the court starts analogizing. You were earlier saying, well, I'm analogizing. Now the court's making an analogy. And to my mind, it's a perfectly apt analogy. Hey, the president retweets all the stuff all the time. Do you think he's in a conspiracy with all these people? No? Okay, then why is it different here? That's a perfectly valid line of argument to my mind. The court, I understand that, but what you're saying is that anyone who retweets that you do, you got a conspiracy with the person. Mr. Beard says, I think it's rational to infer. Okay, it's dismissed. I agree with the court. It's not rational. It's not rational. It's a bad argument. It's a bad argument. Okay, tortious interference with the existing contract. Mr. Beard, same answer. Whose contract did she give him a contract? She did not, as far as we can tell. Okay, so that one is dismissed. Who did she contact to give him his contract? Okay, tortious interference with future business. Same answer. Okay, well, that's dismissed. Well, if all you have is the same answer again and again, then it's going to be dismissed. Who did she contact? Who did we contact? She didn't contact anyone. Okay, that's not tortious interference. Right. Exactly 100% correct. Did she contact someone to interfere with the contract? She didn't contact anyone. Not tortious interference. Ta-da! So we identified the issue and dismissed the case in less than half a page. No problem. Dismissed. There's vicarious liability. I don't know. Is that a cause of action against her? That is. So vicarious liability requires they be an employee, not an independent contractor. Okay. And then they conspired. Okay, scratch that. Let me find my actual notes here. Your Honor, if I may, I believe in the amended petition is limited to Funimation. I thought it would be too, really. Yes, Your Honor. Because it would have to be one of her employees who's vicariously liable. Right. That's vicarious liability 101. She works at Funimation. Right. But it wouldn't have to be her employee. She'd have to be vicariously liable for, not her employee. Okay. No, we're alleging vicarious liability in Funimation. I'm sorry. Were you unclear as to who you were alleging vicarious liability for? And incidentally, I knew from square one, and I'm not involved in this case, that the vicarious liability would be for Funimation. Of course it would be. It's respondent superior. They're the only respondent possible in this argument. So anyways. Okay, so we're done with Mariachi. Those are the only cause of actions. Were they? Yes. All right. Let's do Real. Okay, so all causes of action dismissed against this Mariachi person. I have no problem with this because the case fell apart rapidly. I mean, we read it. You got your day in court and you have nothing. So goodbye. Makes sense to me. Someone asked, as someone saying the retweet, could you construct a retweet as saying I'm in? Probably not. No, and even if the tweet could be viewed as me saying I'm in, that proves me as an accessory, not as a conspirator. There's a difference between being an accessory and a conspirator. You know, to be an accessory to someone is to assist them and help them. It doesn't require their consent. Conspiracy requires their consent. So even if me retweeting or me liking or me commenting could be viewed as me saying, I think this is great, I'm 100% all in, that doesn't make me a conspirator because you haven't echoed me back. There's no agreement. There's no mutuality. So maybe I'm an accessory. I'm not a conspirator. There's your difference. All right, so now we're going to do Rial. Mr. Johnson, if I may, just to be clear on the record, all causes of actions are dismissed with Ms. Mariachi. Yes. So he wants to get that on the record clear, and that's very, very good lawyering. It was certainly implied by what the court said, but he wants to get that clearly stated. Good lawyering. Your Honor, defamation as well? The court, I said that a long time ago. Yes, he did. And now this is the third time he's reminding you of it, so pay attention. Rial and Toy, are they together? Yes, sir. Well, let's do them. May it please the court, Sean Lamone on behalf of these defendants. Your Honor, this case has really been a dumpster fire from the very outset. You know, that's funny because I've been told not to cover this case because it is a dumpster fire. Now the attorneys for one of the sides themselves are describing it as a dumpster fire. So I guess it is a dumpster fire, at least as far as the parties are concerned. So all you guys who've been saying this is a dumpster fire, I guess you guys were right. I mean, it's in black and white, quite literally, right? It has created massive divisions within an anime community, which is not something I've been in, quite quirky. But part of the reason the fire is so big because the Vic is a public figure and is also a limited person public figure. I agree with you, he's a limited public figure, if that's what you're trying to convince me of. I agree with you on that because we don't have many cases that people show up for. So, I mean, obviously there's some following because people are actually here. It's usually very lonely. And fair enough. You know, the court taking notice that people are in the courtroom is evidence of some sort of fame and notoriety. That's a reasonable basis for the court to say that. Sure. I'm looking around. There's a whole bunch of people here for this case. I mean, normally no one would be here. So it must be because it's pretty notable. It's perfectly reasonable. Couldn't name and shame him infer conspiracy? Well, I want to name and shame him expresses my intent. But you need the mutuality. You need two people having an agreement. So if someone says we should name and shame him and the other person says, yeah, let's name and shame him, that would be that you need it's essentially contract. Conspiracy is contract. You know, in the same way, you need two sides. You need offer and acceptance. You need mutuality. You need a meeting of the minds. And so, like, if one person just says this is, and the other person doesn't echo back, you need the call response. You need both sides. So you need something from both parties that shows the agreement. You need something that shows both ends. So someone saying, I want to name and shame this guy, I want to destroy this guy, I mean, that might reflect all kinds of things. That might reflect nefarious intent. It might reflect criminal intent potentially, but it doesn't necessarily reflect conspiracy because there's no mutuality. So just because it's not conspiracy doesn't mean it's not something else, right? That's my whole point. So, like, there is no conspiracy because there's no mutuality. Does that mean it's not something else? No, there's multiple causes of action. And that's why the court's doing them one at a time. Mr. Limoni. All right, now I'll start with this. Given the legal argument, the first two opinions the Texas Supreme Court issued in 2015, in some cases that say specifically the statute is designed for retaliatory type lawsuits. That's exactly what this case is. We have a couple of affirmative defenses. One of the affirmative defenses is that he's libel proof, which apparently is a Texas specific thing. Okay. And that's established in part based on numerous number of articles that were written about him. It has nothing to do with our folks. Yeah. So under Texas law, if his reputation is already sufficiently crap, apparently it's not possible to further libel him. So they're saying his reputation is already crap, not due to anything we did. Okay. The plaintiff's reputation is what it is because of the plaintiff. Now he's taken the position he's done nothing wrong. On the left side are 7 affidavits from individuals that have obtained regarding a large period of years testifying to his terrible reputation, his inappropriate behavior in young girls, being caught in a room with 3 14-year-olds, coming out of the room screaming, "I did nothing wrong," something to the effect of, "I didn't touch them." Mr. Beard, Your Honor, hold on. Yes, I object to all this. That's because none of it's relevant to the hearing, not one of it. The court has already ruled that he's a limited purpose public figure. So if they're talking about allegations, hearsay, affidavits from strange people, many of which were contradicted, it's not relevant. It's probably not relevant. Andy, nice to have you. Vic usually gets around 300 to 500 fans when signing autographs. So he's a popular guy. So limited purpose public figure sounds a lot closer than public figure. I'm personally loath to pull the public figure trigger because once you do that, it makes it so much harder. So I tend to be very reserved when I pull that trigger. But limited purpose public figure is a little bit easier for me because it's limited purpose. So we don't have to make global statements. If we're saying public figure, we're making global statements in all contexts. So, I'm loath personally to pull that trigger. If you're saying limited purpose, it's like it's a specific context. I can deal with specific contexts. So this, to me, seems much more limited purpose. I tend to agree with the court there. They're used to gratuitously slagging him, slandering him, and attacking him in pleadings. It's right there in the face. I invite the court to look at the first few pages. And this is a continuation. The one with the picture, is that the one you're talking about? Yes. And then endless affidavits from people that boil down to random people who have not been sworn in. Well, if they're affidavits, they have been sworn in. So, that affidavits are made under oath. Carrying on, we don't even know what they're saying. Yeah, he's a mean guy. I saw someone who said they assaulted him. There's never been a single criminal charge filed against him. No police investigations. No police reports. And for them to sit here and go through that, it's not relevant. It's defamatory in and of itself. The court, overruled. Yeah, let's just get to the point. Fair enough. Overruled. I'm not striking it down, but at the same time, I'm saying let's move on with our lives. Perfectly reasonable. Mr. Limon, okay, Judge, what it is, he's got a terrible reputation as an affirmative defense defamation that can't be liable. The next argument is the court talked about retweets. Under the Communications Decency Act, you can't have retweet liability. Under 230, can you have retweet liability? I would think the answer to that question would be yes, but let's see what they say. Section 230 of that particular statute, and it's a nasty little creature, I don't think it's been litigated much in the state of Texas. But the statute says if you're a user and you republish something of it, basically the internet service, you cannot, unless you add the content, maybe you retweet it. And it says you're a terrible human being, blah, 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 look at this tweet, you can't be held liable. Is that true as a matter of law? They're saying it's true, but I don't know. They're not citing anything, so I'm not sure if that's true or not. And it's important for this retweet analysis to try to apply to Ms. Mariachi and the retweet analysis that applies to Rial. So you're saying that if I've got a little neighborhood blog and someone posts something really bad about one of my neighbors and I repost that, I can't be liable for that? That's correct. If they say they're stealing my chickens or something, Judge, as long as you don't comment, all you do is repost it. I don't think that means you should be able to repost it either. I don't know if that's correct. There's no liability for Twitter as the publisher, because they're a third party. But if you retweet it, you are now putting it in your own name. I don't think this analysis is right, unless there's some case law on point. So I can repost someone as long as anyone else posted it first. Yes, until they change the language in the statute. It's literal language when you look at it. It talks about users. I don't have it, but it's quoted in the brief. Okay, the plaintiff never even answered, so I don't know what. A CDA has been applied in the state of Texas, not just on this user. Your Honor, I'd like to object to the introduction of this argument. This was filed after the deadline. They raised this defense after their deadline to file the notice to have passed, and they did not plead it. The court, was it your response that retweets are slander? Mr. Beard, yes, okay. I think they can address something they put in your response, because they didn't know that you're going to make a mistake of saying the wrong law. And if you do that, they can bring in the law, right? Mr. Beard, if you misstate the law, I think they got a right to tell me what the law is. Mr. Beard, I didn't misstate the law. Okay, well, he thinks you did. Mr. Beard, well, I know, but if you indulge me, Your Honor. He filed the defense several days after the deadline to file his motion to dismiss had been passed. Now, if we're going to be hard on the context, they filed a whole bunch of stuff after the deadline. I'm not going to consider any of that. What I'm saying is, listen to me. I'm sorry. If you make a bad argument on the law, they have a right to point out why your argument is bad on the law. Yeah, fair enough. The court, I'm not saying that they need to bring additional evidence after the deadline. I don't think you should either. And so that's not what we're arguing about. The law, whether to retweet slander or not, and you say it is, and they got law that says it isn't. They're not arguing fact; it's arguing law. I think we can argue law, can't we? Yes, fair enough. Yeah, we can argue the law. It's not bringing in facts. We're arguing law, right? I also disagree with his characterization of the law, and he might be wrong. That's fair, but he's got the right to bring in cases that support his argument, and so do you. I get the distinction. Okay, thank you, Your Honor. I'm going to address the legal argument. I think you're going to hear. It's written on the back of the whiteboard overboard, and that is in the KNBT case, which is Texas Supreme Court case that came out in 2015. That KNBT somehow overruled objections to affidavits that they produced in the dissent had written in front of it. So you look at the argument they made in the motion to strike, the objections, and you can't do that. What they didn't do in the citation was point out to the court that that was in dissent. You have to make that clear in your legal response. When you do that, you put a signal. When you're citing dissent or you're citing something, you make a little note so that it's clear. And it doesn't mean you can't cite a dissent. It doesn't mean that's not legally irrelevant, but you still have to cite dissent so it's clear. Dissent lost the fight in that particular case. I think it was Judge Johnson that wrote the dissent. The reason why dissent writes it is that he didn't like the objections to the majority that the Supreme Court upheld. And look at the footnote that dissent writes at the bottom. They don't say that you can't have objections to evidence. They just disagree with the analysis. Your Honor, anyone that makes an argument to the court based on dissent, there's some kind of weird you can't object to evidence, I can put whatever in my affidavit is simply incorrect. And also, I don't think there's much more to discuss than that. Mr. Beard, may I respond? Could I turn the exhibit around? Because I don't think counsel's accurately. I'm not sure what it has to say. The court, I don't know what he's doing either. I'd just like for you to go through defamation. I think as to the conspiracy, which I don't think there probably is one, unless Tor has one or Funimation has one, but I don't think it has to do with mariachi. Someone said, I don't think this is going up for another 20 hours. Well, someone apparently paid to have it released. Someone paid big money to get the transcript early. So, are you asking about my my thing? No, I announced this at 12. But if you're meaning the transcripts, someone paid for the transcripts. I think my vid. No, yeah. Texas law and the United States Supreme Court law says if you're going to, I'm going to have incidentally, I will have a live stream tomorrow afternoon on Twitch. I think it will be on Twitch, but I'm going to do my weekly live stream. But this story is too big for the weekly live stream because it would just consume all the time. We've already spent an hour and 8 minutes on this. So, it's too much for the live stream. So I thought we'd have a special stream just for you guys, just to cover this because that's how much I love you. And I wanted to make sure to give this the full weight of it because people are interested in it. Apparently, a lot of people are covering it. And, Leonard says he doesn't want to cover it. And Legal Eagle says he doesn't want to cover it. I'll cover it. Why not? I don't have a dog in this fight. So I'll just cover it and read it and see what I think. So far, so good. Texas law and United States Supreme Court law says if you're going to sue someone on libel, you have to put it all in because you don't examine individual statements. Because he's a predator without context, you don't know what that means. And I would think predator probably is opinion, but whatever. The tweet above it, could be dressed like he went on Halloween, what he did. And the answer is he's a predator. Fair enough. Now, I'm not going to, yeah, fair enough. I mean, context could remove something out of its apparent defamation state. Now, I'm not going to pretend that this is a discussion that's been had here, but in order to meet a clear and specific burn, their job is to put the entire set of tweets in by way of example. Yeah, if you by this point, you have to be more specific. Texas has notice pleading, but we're not at the pleading stage. We're a little bit further along, so you have to make it more specific because we're in this response period. Right, no problem. Exhibit 28 to the deposition is 320 pages of tweets. They didn't put the context in because you have a tweet in the middle of just blank pages. And next page, there's a tweet at the top and then blank pages. Okay. The reason why I think they did that is the way they were being written was so awful by plaintiff's fans. They didn't want to show the court because of a much shadier view of what his fans were doing, what was happening. Fair? But if they showed they were defaming him 100%, the court can't rule on that as a matter of law because you don't know what the text is. You can't just put in the petition on this date that he wrote he was a sexual predator is liable. Probably true. But no one's asking for that. No one's asking for summary judgment. We're on a motion to dismiss. So no one's asking for the court to rule that it is defamatory. We're just asking, is there enough for this to go forward so far? If it's tweet, you have to point out the tweet in entire context and the court can read it. Well, enough context to figure out what it is, yes. For how many days was that 300 pages of tweet? How many days did it cover? I don't know, Your Honor. Okay. Because some of them, they don't have context. Plaintiff's counsel testified, some of them out of order, so we don't know. That's okay. Your Honor, may I? I don't believe we ever said anything that was out of order, but in response to their motion to dismiss, we did put in all 300, and tweets are not ambiguous. They're not a wash of ambiguity at all. I think we can see that his client said stuff about Vic. Yes, okay. And I would point out, too, that they're all authenticated by this court in a previous hearing. Oh, really? Yes, all that exact. The exact stipulation was all the tweets are authenticated. We're not backing away from that, Your Honor. What is not authenticated is the blanks, because you don't know what he's responding to. As you know, that is Hornbook law. A Hornbook is also called a treatise. It's basically a summary of the law. It's also called a restatement of law. So when he's saying it's Hornbook law, it's basically saying it's black letter. It's so well established that it's being published in these authoritative third-party documents. That's what they did in the Madria case out of the Fort Worth Court of Appeals. That said, we don't know the context is. We got to lay it right. All he has to do is print the context out, send it to the court, and matter of law determine whether or not it's defamation per se. If it's not defamation per se, it's defamation per quad. Yes, it is. If it's not on its face, it's by its proof, yes. Are you right saying that with the facts she published, the statement was defamatory? It applies to all the tweets because everything else, there's only one tweet I can think of that's full context, and that's it. I'm trying to get through the causes of action for defamation right now. And so what element are you attacking? Well, the falsity element. Okay, you can't prove it's false if you don't know. It's hard to prove some stuff false. I'm sorry? It's hard to prove some stuff false. That's true. And what the court says is not on this page. I mean, if he says he's a pedophile, prove it, then he's not. I mean, how do you prove he's not? Yeah, very fair point. You can't, it's hard to prove a negative. Some other things. What fans do is irrelevant. It's probably irrelevant, yes. But so, the relevant question is, what is the relevant context? So that's what they're arguing over. Fair point. Is context more relevant for the actual judgment? It's relevant at this stage too, because we're trying to determine if there's enough to go forward. So if you're removing context, like, if I say person X is a pedophile, that sounds pretty bad. And if you put that in your pleading, they said person X is a pedophile, that's pretty bad. However, if in broad context, I'm saying it in a way that's not defamatory because of the context, then I'm removing information from the court need to make a decision. So you do have to provide enough information to show whether it's defamatory or not based on the context. So it's relevant to what's going on now. EZ07 says, I've been following this since the start, a lot back and forth on Twitter, and defense saying a lot in reply in the question, just FYI. Seems a bit too in-depth for a motion to dismiss. No, I don't agree with that. It seems basically typical for a motion to dismiss. They're trying to get at this stuff. It seems right for a motion to dismiss. Robert says, sure, they have present evidence at this point. If they can't show evidence now, it's time to dismiss. Exactly right. And so it's a little in depth, but they're like, well, we need to figure out what the right level of inquiry is, right? And all Vic needs to show is plausible facts, reliable facts. They need to show something that's credible, basically. Some credible facts that would make it true. And so there's like, well, here's some stuff. And the other side is saying, well, it's removed the context. If the context removes the defamatory sting, that's a relevant argument. If in context it's not defamatory, well, motion to dismiss. There's not enough here. So, okay. The court says, you're not listening to me. Well, how do you prove he's a pedophile? How do you prove he's not? How do you prove he's not? Well, I mean, one of the things is that they're doing, he's never been arrested. He's never been convicted. That's a bad thing saying stuff about this. You can't prove you're not, the allegations out there. So the court is now giving defense a hard time. And so at least, this shows the court's being fair. They're giving defense a hard time. It's like, you can't prove a negative. And so the allegation's out there. So yeah, he's giving defense a hard time. And so the record's clear. There's no evidence we ever called him a pedophile, but there was somebody who did. Well, the thing is, that guy kicked off Twitter. Some Twitter person says he's a pedophile, and that caused an eruption of Funimation's Twitter page. But my folks never said that he was a pedophile. Was that Sabat? no, Judge, that was Mr. Huber. I'm just looking at their response. It says rumor of Vic's being an asshole, using his hands, and being a pedophile were begun by Funimation's de facto manager, Chris Sabat. That's in response to the, you don't have to keep standing up. You had your turn. Okay, I'll get another turn. I just really want to clearly go through the elements of the cause of action to see if they should be dismissed, and you're bogging it down. So the court's whacking them around for wasting time. Court's trying to get to the issues. Mr. Lemon, so the first argument obviously goes to falsity. If they don't put entire context of the tweet, the court can't make a determination. Right. So you have to have all the relevant context so that we can make a determination. Is it a defamatory statement or not? The second element that I would tack is the clear and convincing standard. I think the court is convinced based on earlier statement that he's a public figure of limited purpose. I think he qualifies as limited purpose. Okay. And that means actual malice. Actual malice means either you knew it was fault or failure to investigate. Right. Actual malice is perhaps one of the more poorly named things in law. Because normally in everyday speech, when we talk about malice, we talk about hatred. In defamation, actual malice has nothing to do whatsoever with hatred. It has nothing to do with intent. It has to do with reckless disregard of truth. So perhaps poorly named, but we're stuck with it. What do you want? I think that basically gets to what they did. It was an actual mistake by them. They introduced all this deposition and all this other deposition. So the court has, with regard to depositions, the ability to look at what their intent was. So when you do that, you put all the evidence in it. We put this in a reply brief. There are pages and pages of saying, I have 4 different women tell me they saw them. I did internet research, read articles. There's voluminous evidence about the information out there about the plaintiff I had to look at and determine I felt it was truth. There's nothing in his deposition that shakes him off that. So they introduced his deposition. They effectively crippled themselves. TY conflated the two a lot. Yeah, you shouldn't conflate things, man. It's not good. It's not a good look for the court. You know, you need to make sure to keep things into their separate boxes so we can all move forward in our life. There's no evidence in the record that the plaintiff ever told this person anything that would cause him to have a belief in that information. Even if the court were to go hunt and peck through 320 pages, you're not going to get any evidence that he didn't believe it. So they're talking about his subjective belief as to whether or not he was acting with malice within the meaning of this or not. Okay. And same thing applies to Rial, because for her, she says that she was assaulted by 2 friends. They were twins. They told they assaulted another woman who did the same thing. The plaintiff has her describe it over and over in the deposition when it becomes introduced, which becomes evidence as to the malice element. So I don't know how, I don't know why, I certainly don't know how we get past that. So that handles the actual malice argument. I think you're going to hear an argument that the plaintiff has denied assaulting, and because he denied it, that means they meet the actual malice standard. That would be a wrong argument. That's not right. They roll out 2 pieces of evidence. The first one is a man named Stam Dalan that Mrs. Rial said after he assaulted, he knocked on the door. I went out and asked me how I was doing and went to dinner. Mr. Dalin says I have no memory of that. It goes on to speculate about what he would have had to remember, but it's not clear. And specific evidence is it didn't happen. That's clear and specific evidence that has no memory of anything occurring. Yeah. The defendants hate my client, therefore they acted with actual malice. That's not what malice means in this context. It has a specific meaning in this context. So yeah, if you conflate the two, that's not a good thing. No. No. Don't do that. Same pattern with regard to the plaintiff. When I deposed him, I laid out the argument and said, here's what she said you did. Did you do that? Did you disagree with that? His answer, I don't recall. He said a couple of other places. So if you're trying to sue Miss Rial based on theory that she was lying about what happened, the only person that could have set it up is I don't remember. So she cannot be falsely testifying, or they cannot meet the burden of it. Ooh, yeah. So maybe Vic was too clever by half on that one again. So they're saying, let me go back and just make sure I read that properly. When I deposed him, I laid out the argument and said, here's what she said. Did you do that? Did you disagree with the answer? Is that I don't recall. So that's being too clever by half, because if it were I didn't do that, I didn't say that, then you have the tension point. And so you can make the malice. Because if you're saying clearly this is false and they're saying it's true, that's more suggestive of malice. If you're saying is I don't remember, where's the tension? Where's the tension between the true statement and the other statement? There's no tension. So I don't recall might be an answer that was too clever. If this were in Germany, Vic had an actual shot of winning this. I think he had an actual shot of winning this in the United States, for that matter. It seems like there were some missteps. You know, the Discord stuff apparently is not on the record for some reason, even though that would be fantastic evidence of potential conspiracy. The Discord, and it will be a whole bunch of statements showing an agreement and a plan and an execution of the agreement. But for some reason, apparently that's not on record. I don't know why, but it seems like pretty good evidence as to the conspiracy. And I would imagine there's statements in the Discord that might actually go to defamation as well. But that's not on the record for some reason. Court can't analyze what it doesn't have. So yeah, and as to like these things that he's saying, like, it's like, well, did you say it's false? And he's saying, well, I don't recall. It's like, well, then how can she be in manifest disregard of the truth when you're not clear what the truth is? You testified, I don't remember. So it's like, how can it be manifestly untrue? And also Germany, I don't know how they deal with public figures. So I don't know like German and malice and how they deal with public figures and the distinctions there. So I have no comment as to that, you know, as to other law. And also UK law, for example, takes defamation a lot more harshly than the US. So this might be liable in UK law, but it's not in the US because we have different standards. So yeah. Hello, 1234. How are you doing? Let's see, where were we? Yeah. The court, you're talking about her statements with regard to actions. That's correct. Okay. A difference of opinion is not slandered. Oh yes, opinion. A difference of opinion. Well, the difference of opinion as to what happened, if she's talking about her own personal situation, is you're saying what she's talking about. Okay. That she was assaulted. That's right. Okay. That can't be slander because they have a different opinion as to what happened or a different idea of the facts that happened. I don't think it's slander just because they disagree with the facts. Okay, fair enough. Well, and I would concur. And what I'd say is, even if you did think it's slander, you can't get to actual malice because the two people dispute over what they thought happened. The court, that's what I'm saying. It wouldn't be malicious to have a different feeling on something. Yeah, okay. So if they both broadly agree that an incident occurred and they disagree as to like some of the elements of it, the differences of opinion, it's not malicious within the meaning of this statute. Seems reasonable. 1234 says, I like your videos of Ace Attorney. You are a real attorney. Man, I don't know, man. Ace Attorney was driving me a little bit up the wall because of it driving me through the particular narrative. Like, I want to get to the absurdity. I don't want to have to like figure out like the exact order of things I have to click on. That was annoying. So I don't know if I'll do more of Ace Attorney. Although Ace Attorney is my best performing video on my channel. So yeah. So with regards to her assault and their assertions that she called him a sexual predator, which is the reason why the inclusion of the testimony is fatal to the argument. But she goes through the investigation. She knows about her participation in the investigation, the woman who specifically told her that she assaulted them. And I know that plaintiff has denied these allegations and said it didn't happen, but it doesn't mean that those women didn't say it didn't happen to Miss Rial, and certainly doesn't mean that she had reason to question him, especially given her own interaction. And her statement, the reason why she came out is very similar to what the defendant said, which is what I want to corroborate with other women that were suffering in this way. And so regardless of what they try to classify the statement as assaulted, and that's defamation per se, or a sexual predator, that's defamation per se. Under either scenario, the evidence they put in the record, they can't get to the actual malice standard. The tortious interference claims, they're just as bad to us as they are to everyone else. The Kahn case out of Fort Worth Court of Appeals is pretty blistering. It says if you're going to say that someone didn't breach a contract or whatever, you have to go in and get an affidavit from that person. Well, even if there wasn't a case that said it, I would imagine that's just good trial practice. You know, if you're going to say someone tortiously interfered with my business relationship, it would seem like even if there wasn't a case that said I need it, it would seem like just a good idea to get a deposition or other evidence from that person. Hey, person who canceled my contract, why did you cancel my contract? Here are the reasons why. Okay, well, that would be helpful, you know, going forward. So like, even if there wasn't a case that said you need it, just from purely practical matter, it would be really helpful. So yeah, there's no evidence of any convention or anything else, a breach of contract because of something the defendant did. Is there one where it ended up going? Is that one he ended up going to? Okay. So as to that one, yes. So that's a complete dud. Yeah, it's not a breach of contract if he eventually wound up going because it undid the damage. Even if it were a tort, the damage is like de minimis because he wound up going and getting his fee. So like it didn't matter in the end. There's no tortious interference with an existing or prospective contract. That's all. They all got to go to Comic-Con and they judicially admitted there was no damage. So that's the end of the tortious interference claim. Yeah, pretty much, because all you'd be left with is nominal damages. So like if you want your $1, we'll give you $1. Different contract for the same place, that's what it looks like. It looks like they canceled the contract and then uncanceled the contract. And so there was no damage. There's no interference because the contract eventually was fulfilled at the same place and no damages. So yeah, we can dismiss it or we can keep it alive and give you $1 in nominal damages. Your call, right? So regarding to conspiracy, if you don't have an underlying tort, you don't have to prove a derivative tort, you can't get conspiracy. And so there's no evidence of any derivative tort with regard to anyone else. You have already dismissed the Miss Mariachi, and with regards to her claims, he can't get there on defamation, and certainly can't get there on tortious interference. Hold on for a second. Okay, where are we? I think it's in response, Your Honor. Okay. I'll start out by addressing Section 230. Section 230 simply says that, for example, if I post a tweet that's defamatory, Twitter is not responsible. On the other hand, if Twitter posts a tweet that's defamatory, Section 230 doesn't get them anything. That's a fair statement. Twitter, as a host, is not responsible for what other people say. They are responsible for things they say. So if Twitter tweets on their own platform, they're responsible for those tweets, but not other tweets. That is a fair statement of 230. If I share a defamatory tweet, Twitter's not responsible. But if Twitter shares a defamatory tweet, it is responsible. Makes sense. Section 230 is not a get out of jail free card for everyone to post stuff on the internet. So there's that. Counsel had an interesting argument. The court, but that doesn't mean there's a conspiracy. We're back to this again, right? We're back to the distinction between defamation and conspiracy. If I retweet you, it might be defamation. It's not conspiracy because there's no meeting of the minds. There's no mutuality, blah, 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 blah. I mean, that's where your problem is. I think that personally, if they retweet something, that's defamatory. I think they might be on the hook for it. But I don't think in a conspiracy with a person that I tweeted in the first time. I just tweeted what he tweeted. I didn't have a plan. Correct, Your Honor. And if we were a trial, I'd agree with you, but we're not. We're at a point where, why do we need a jury question if you agree with me? Excellent question. Well, you already agreed with me at trial, so you can see directed verdicts. So what's the difference? I did not intend to do that, Your Honor. Well, you kind of did just now, but you're a bit lost. Yeah, was the conspiracy dismissed? It was dismissed with respect to one plaintiff. It was dismissed with respect to the first plaintiff, yes. But now we're moved on to, I apologize. It was dismissed with respect to the first defendant. Yes, it was dismissed with respect to the first defendant as to her conspiracy. Yes. So now we're on to other defendants. Now we're wondering if other defendants conspired. So we're wondering about other things. So we dismissed as to the first defendant. So that we moved on. You are agree with me? Okay. What I'm saying is that we're required to prove prima facie evidence. At this stage, I'd say respectfully that when two people engage in numerous tweets attacking someone, calling each other's, it's rational to infer they have a conspiracy. It's really not. I'm sorry. It's just not. If we're just generally good friends, which was your argument, incidentally, if we're just generally really good friends and really good like acquaintances with each other, it's not surprising that we would like each other's posts or retweet each other's posts or echo each other's posts. It doesn't mean we're in a conspiracy. It just means I like you and I like what you say. And so I'm going to echo it because I think it's right. There's no mutuality just because we're friends. You need more. You need an agreement. Even if they're engaged, it's not enough. Even if they're husband and wife, it's not enough. Their husband and wife, they really like each other. They really like each other. So of course they tend to agree with each other, but it doesn't necessarily imply the conspiracy. You need a little bit more. You need an agreement to undertake something. Okay. So we have following defamatory tweets from Miss Rial we can start with. In response to Vic, and I could put that on screen if you want to see it or whatever. But she's responding to comments about Vic and Vic is named. She said the truth will come out. All of it. She said, and the context here is very clear. That's in Fundamotion's motion to dismiss as well as ours. In addition, we have her saying, let's see. And just so we're clear, he's the legal definition of harassment. Harassment is governed by state laws that's generally governed as a course of conduct which annoys, threatens, intimidates, alarms, or puts a person in fear of their safety. She later goes on to say harassment laws, which vary by state, are defined as a course of conduct which annoys, blah, blah, blah. And that's the same thing. Yeah, harassment laws vary by state, but that's a very fair sort of generalized definition. Here, this is a really good one. There are investigations conducted by multiple companies with evidence, testimony, and truth. There are dozens of men and women who participated. The companies don't have to share information with you because you're not an attorney or law enforcement. There's been no evidence whatsoever from any of the parties that this is the case. Again, it was just attached. In Chuck Huber's affidavit or sworn declaration, are you not sure which it is? He testifies that he made statements, and I'll get to it right here. In Chuck Huber's affidavit, which I remind the court we're supposed to take as truthful, generally speaking, that's true. Generally speaking, you take things as true unless it's not credible. So you can say this is just garbage. Your court's allowed to say this is garbage. So yeah, carrying on. He says Funimation employees, including Jamie Marici, Monica Rial, and Michelle Speck, have advised me more than once since February 19th that criminal charges are coming. In response, I encouraged them to help alleged underage victims of rape and sexual assault. When asked to provide specifics, they couldn't do so. All right, we have a real devastating evidence with Mr. Slosh, whatever, with Comic-Con. In this guy's affidavit, he said, I've got it. In the affidavit, he flatly states that Rial and Toy verbally urged him to dump Vic Maglione. Okay, so that seems like tortious interference. They're threatening him with having other voice actors pull out of the convention. They said there would be criminal charges pending, that he told him that he'd be charged before the convention, and said, okay, I'll drop it, and he dropped it. That seems like tortious interference. Now he breached his contract. There was a dispute between them, and they got it worked out. He goes back to the convention, but a number of limitations were not imposed on other voice actors. He did more or less point out. So this is the one where he went back to. So this is the one where you're saying, let me make sure I get this straight. You dropped it, but then you went back, but you already said there's no damages, so it's not tortious interference. So you undermined your own case. You went back, but you already said there's no damages. So now you're saying there's all these limitations that were imposed on you. Okay, but you already said there's no damages. So it's not tortious interference. If these limitations weren't damaging to you, it's not tortious interference. Carrying on. This guy testifies to all that. In addition, we have text messages that say these things, and we have these conversations they had. He testifies, these are the lines. So they established a conspiracy between them two. Tortious interference, and establishes, okay, so you're using this as evidence now of conspiracy, not the tortious interference. Okay, I buy that. So I find it curious we have actual evidence and testimony they did, and opposing counsel says, there's no proof they did to any others. I believe it's a rational inference. This is a pattern of conduct. This is only one we're able to turn over before discovery stay kicked in. And in addition, Rial managed something like 25 emails with these people after he'd already been terminated, discussing things like, what to say, what to do. The emails were very, very thorough. That seems like conspiracy too. Although if they're employees, it's probably not conspiracy. There is a division of law on this topic, but there's a division of law as to whether or not you can conspire with your own employees or fellow employees of a common business, because there's an idea that a business is a legal person, right? And so if you are employees and talking to other employees, then it may not be conspiracy because there's not two distinct people within the meaning of the law. So there is a division of authority on this point. So I don't know which way Texas goes on that issue, but just an FYI. By the way, Funimation did not attach a copy of the contract. They simply said she's an independent contractor. It's a question of fact and law. Well, let's just assume it's true. Do you have a breach of contract case against Funimation? Do we? No, we don't. Do you have a breach of contract case against Comic-Con? It's Comic-Con. That's cute. From Dragon Ball, right? Comic-Con. That's cute. Yes, Your Honor, we would have. Why didn't you? We worked it out so you didn't have any damages. Well, we did have damages. Oh, we did have damages. And were you compensated? No, but they did have to hire extra security. But you conceded to that. So you entered into a contract with him and you conceded to that. So how are you damaged if you chose that? That's a very fair question. No damages doesn't mean no crime. The response is exactly correct. This is a civil case. So no damages means no tort would be a correct statement. So no damages, no crime, probably true. No damage, no tort, that is correct. If you're not damaged, it's not tortious. So you're just dead. It was amicable settlement between the parties in lieu of litigation. We're not saying that only damaged by them. Okay, how else were you damaged in the interference with the contract? We're damaged because multiple conventions canceled. That's not an existing contract. Right. One deal at a time. The tortious interference as is to each thing separately. You have to show them each. So one thing at a time. Mr. Beard, well, here's the thing. They would have, at very least, the court would indulge me. I think it's fair to say they attempted to tortiously interfere. They attempted to. Oh, well, geez, if they attempted to tortiously interfere, let me show you how much cares I have. Look at all the cares I give. They say he lied about the fact he was a predator. They lied about the fact he was going to the criminal convention. They threatened the convention. Blah, 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 a whole bunch of other stuff. The court says there has to be a current contract in place. Hold on. So there has to be a current contract in place. These people had to get together and interfere with that contract. Which contract did they interfere with at that place at that time? Good question. At this time, they interfered with the Comic-Con contract. All we can do is interfere. If they did in one case, they had done in others. Would have is not a cause of action. They didn't. They would have other means, they didn't do it. If someone walks to you up and tries to hit you. But if I rob a bank and they don't catch me, or if they do catch me, they can't charge me for what I would have robbed some other banks. Yeah. Even in criminal law, intent alone is not enough. I can have intent to commit all kinds of crimes. If I don't actually commit the crimes, it's not illegal. Which is a good thing because sometimes I want to do illegal things. But I don't do things, so it's not illegal. Mere thoughts are not enough. Andy, did you ask if it's RICO? First of all, RICO's criminal. In the civil context, no, because it's not in the RICO statutes. So no, it's not RICO. Mr. Beard, fair. But Your Honor, if someone walks up to you with a baseball bat and takes a swing at you and miss, isn't it fair to infer they might do it again or might do it to other people? But I can't. I don't have a cause of action for what they might do. Yes, we are not in Minority Report. What they might do is not relevant. Your Honor, you don't have to do that. All we have to do is produce a minimum quantum of evidence necessary to support a rational inference. What you got to find is a rational me to say if they interfered with the Comic-Con, they might have well done so with other conventions, and I point to those conventions they canceled as evidence. But that can be prospective contracts. They aren't current contracts. No, Your Honor. Plaintiff testified in many cases he did have contracts with him, verbal contracts. Well, that's why I'm asking with you, court. Stop. Oof. When court's yelling at you to stop, you know that you should stop talking and pay careful attention. I asked what contracts were in place they interfered with. You said Comic-Con. That's one. Okay. There are multiple other conventions. Plaintiff does not remember specifically which conventions. But in his affidavit, his testimony is supposed to be taken as truthful. Some contracts he had, some he did not. He was coming back on all kinds of stuff. How much money did he lose? Oh boy, that I can answer. So the plaintiff, it's hard to give you an exact number. Well, I said, the court's busting his balls. Do you see this? Mr. Beard, oh boy, that I can answer. So as to the plaintiff, it's hard to give you an exact number. The court, well, you said, boy, can I answer that one? I thought you were going to give me an exact answer. Schmack. Oh, Lord. Mr. Beard, no, that's not it, Your Honor. The court, I was looking forward to it. Oh, I can feel the sarcasm on the page from over here, guys. I can feel the sarcasm dripping off the page. Oh, man. Mr. Beard's in trouble. Mr. Beard, well, he anticipated it. I'd be happy to go through the methodology. This is not mere speculation. He anticipated it was 5 conventions canceled. He lost $30,000. Did he have a contract with them? Some of them he did. Which ones? I don't know. How can you not know? How can you not know what contracts your client had with what conventions? How do you not know? What are you talking about? Oh my Lord. Oh boy, I can answer. I don't know. That's where we are at this point. Andy, I know you only used RICO as a joke, but I chose to answer seriously anyway. But yes, that's fair. Let's carry on. I don't know. He said in his affidavit that some of them, all of them, they had a handshake agreement for him to appear. You didn't at any point ask your client, who did you have handshakes agreements with? Whose hands did you shake? Or if you're using that metaphorically, like, who said yes? You didn't ask him that? Okay. There wasn't a deal where they had appeared at these conventions over and over. So in many cases, hey, Vic, we want you to be there. Will you? Are you going to show up? He said yes. They announced him. Well, if they announced him, then you should probably know which ones they are. Who is they? That's a binding agreement. I doubt that's true, but moving on. They incur. There's offer, acceptance, consideration. Will you come? Yes, I will. This consideration will pay you an airfare. We promise you. You're moving into there might be a contract, there might not, but who are they would be a good question. Lord. So yes, there were very definitively contracts, Your Honor. 5 of these conventions, he estimated he would have made a minimum of $20,000. Lord. If we applied the averages to conventions, the number would have been higher, like 30,000. 7 or 8 others that canceled were smaller. He estimates 5,000. Again, here are conventions he attended. Comic-Con he made 37,000. Savannah 13,000. Central PA 5,000. Puerto Rico 11. Bach Anime 5. Anime Mazurte 30. Super Worldcon 5, Ireland 12, Liberty 14, Jacksonville 12, and Bubba Fest 17. I want to get money to go to Bubba Fest. Now, if he made so much money at the conventions he went to, despite all the damage to his reputation that he had, if he had dozens of others canceled, you're talking about very serious economic opportunity. Which ones, counselor? Which ones? We've got people doing it legally. We've got testimony the court is required to accept as truthful. We've got actual copies of the text messages. Then you should be able to know which ones they are. Now, we managed to mitigate our loss in the case of Comic-Con, but the fact is they tried to destroy our business with one convention. It's entirely reasonable, rational to infer they probably did so with other ones. In addition, in the convention owner, again, the plaintiff testified to this, the convention owner told him, we're canceling you because of the allegations. Do you have affidavits? No. Discovery. What do you mean discovery? There's a discovery stay the minute they filed the thing. Well, how'd you get affidavits from anyone else then? Got them before. No, you didn't, because you did one on September the 2nd. Mr. Beard, Your Honor, these conventions are not willing to come out. Hold on. You did an affidavit or a statement, whatever, unsworn statement or whatever, September the 2nd. So we were able to get affidavits from people and actually notarize some of these affidavits after discovery. That's the question I asked. Did you get an affidavit? No, we didn't. Okay, you said no because discovery. Right, because I said discovery kicked in. We couldn't go to third parties we didn't know about. You can't get an affidavit. When they filed their motion to dismiss, a discovery stay came down. Can they not get an affidavit during discovery stay to support the response? No. Of course they can, Your Honor. Okay, which is exactly what Sean did, Your Honor. You can't, how do you? Here's the thing. We couldn't depose them. I didn't ask you about a deposition. Did I? No. Let me back up. We did not get affidavits because the parties were not friendly to us. The court, okay, don't make up some other excuse like it's in the rules somewhere. I feel that one, guys. I feel that. I feel it over here in my soul, man. Oh, I feel that. He just got called out by the court. Oh, that's not a good sign, guys. Oh, I feel it. Oh, Lord. Mr. Beard, I got confused. I'm not sure I believe you, Mr. Beard. I misunderstood. I got myself roused. Sorry about that. Okay. Is that all the evidence you have with tortious interference with the existing contract? I believe so. Let me check real quick. Let me see. We went over to that other guy's declaration, the verbal statements, the text messages, the conventions. Yes, I think that's it. We have actual attempts to interfere, circumstantial evidence of dozens of conventions. Okay. Those are both dismissed. Yeah, I don't know if it's dismissed because of lack of evidence or dismissed because Mr. Beard apparently made a fib. But either way, things are not going well. I've not dismissed defamation yet. I have not dismissed conspiracy because they may be wrapped up in the defamation. Does she have vicarious liability? Okay, who is her employee? Funimation. Is her employee? My mistake. Funimation has a vicarious liability problem. She does not. Am I not being clear? No, I'm not listening, Your Honor. It helps if you do. Oh man, this is not going great. The court, okay, so I'll deal with the defamation and civil conspiracy later. How about Toy? Toy, okay, well, let's deal with his tortious interference with an existing contract, not a future contract, not one you just think you have. Let's talk about a real one. Oh, the court. Oh, the court is just smacking. The court is now just smacking Mr. Beard all over the place. The court has just now smacking him all over the place. Oh my God. Oh. Well, he attempted to interfere with Comic-Con, as I just stated, because he did in text messages as well. So I got that. We got text messages for that. He texted that. Charges were going to be filed. Vic is a criminal predator, and we got all that. That's solid. We also have testimony of convention owner that told him charges would be filed. He's a sexual predator. He threatened the con owner with pulling the $25,000 of sponsorship money and so forth. Court, and your guy went to Comic-Con and got paid? The court. He says, yes. The court, okay. Mr. Beard, he incurred additional expense. The court, any other tortious interference with existing contracts? Mr. Beard, other than a rational inference that if he did it at one and did a bunch of others, they would likely done other. Who else canceled? There were 12, at least a dozen. It's in our original. I thought you said it was one. No, Your Honor. I'm talking about, you said it was one at Comic-Con. He went ahead and did it, but okay. Show me those contracts. Let's see them. Well, plaintiff testified a lot of them were verbal, and we don't have written agreements. How much were they for? Well, it doesn't work that way. Okay, I'm sorry. I'm trying to answer your question, Your Honor. Okay. What happens is the plaintiff is guaranteed a relatively modest amount, like $3,000 or $4,000. Exactly how much does he say he's guaranteed? I want to know the evidence, not yours. Ouch, 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 ouch. Things are not going well, man. Tuck your tail between your legs, man. Things are not going well today. It depends on the convention. What does the affidavit say? His affidavit doesn't speak to his guarantee. It simply says their contracts to appear. So it doesn't have an amount of damages. No, it does have that. Okay, how much? Christ, how many times does the court have to ask the same question? All right, well, I told you earlier, we have 150, 5 big ones, and then I don't care which ones he got paid on. I want to know who he's going to get paid on these. I understand. I'm talking about the 5 canceled because he earned the ones that done. He estimated at least $100,000 on the 5 the big ones. There were 7 smaller ones, and he estimated he would have made $5,000. So $135,000 are dozens, and that's not just speculation. That's an average of the conventions. And do you have any evidence from those people from the conventions that say they dismissed him or canceled a contract with him because of interference by another person? No, Your Honor, but the Texas Supreme Court has been real clear. Circumstantial evidence is often required to prove conspiracy and tortious interference. I don't know that can possibly be correct. I don't know it's possibly correct. The Texas Supreme Court has been clear that circumstantial evidence is required. I can't believe that's true. I would think direct evidence is always sufficient. So I have my serious doubts. The Texas Supreme Court said that circumstantial evidence is often required. I have a very difficult time believing that's a fair statement of the law. In fact, even in cases where business says it wasn't interfered with, tortious interference can be found because, who's going to come out and say, yeah, they threatened? A lot of people probably would. Yeah, but what if? Do we have information? Because these are only 3 people that post it. These aren't the only 3 people that post on the internet. These aren't the only 3 people that post stuff on the internet. The court is irritated. Correct. And I assume there are other people that posted stuff on the internet regarding your client. Yes. Okay. How do we know it's their post that caused this? Because, well, number one, if you're talking about tortious interference, we have him actually doing. Are we still in tortious interference? Yes. Okay. We have him actually doing it. Toy? Right. Ryle as well. We're done with Ryle. Okay. Yeah. But I don't know. We're on Toy. Okay. We have Ryle Toy actually trying to do stuff. And he didn't do it, though. He wasn't successful. Okay. Only because the parties were able to work out an arrangement. Stop. It's already dead. Oh, man. Again, it's totally rational to infer that he would interfere with one convention. Why on earth would he interfere with the others? Well, you know what you could have done, counselor? You could have gotten statements from those people. And you say, well, we were barred by the discovery suit or by this anti-slap motion. Well, I'd like to remind plaintiff's counsel that they have control of the timing of the lawsuit because they chose when they got to file. So if the issue is, well, we can't get this information if this thing happens, maybe you should get the information before you filed the lawsuit in the first place. You could do discovery immediately after you filed the thing. You could get statements from them or some statements from them and affidavits. You could do all that stuff beforehand. So you don't have to wait to some magical time. You're the plaintiff. You're in control of your own case. Why didn't you get affidavits before you ever filed the lawsuit? How about that? or some statements or an email. How about that? An email from them. Could you get an email from them saying that? Just an email? That would be helpful. Lord have mercy. Mr. Beard says, I feel like we're being held to a preponderance of the evidence standard, Your Honor, and that's not the standard. The court says, I don't think you have any evidence. That's your problem. Oh, Lord. Your Honor, with due respect, the evidence is that guy's deposition I referred to, testifying that he did. Okay, but he wasn't damaged from that. I understand. Well, I disagree. Okay, he was damaged. He just wasn't fully damaged. He did have to pay for additional security and less desirable location from other voice actors, What's the value of that? I have no idea, but he's damaged. You asked the question. He was damaged. It's hard at this point in the case without the ability to discover, It shouldn't be that hard. How much discovery he bought, right? You know the value of that. You could probably give some estimate of the value of the time. You could get an expert to say, this is the value. You could go to a third-party expert and say, give me some evidence from a professional person to say, well, this other voice actors, maybe an expert witness. There's lots of ways to accomplish this objective. Just saying. Geez. And also, after a motion to compel, because these people have also engaged in very serious discovery abuse. When the stay kicked in, I assumed we probably couldn't enforce that. But the motion to compel discovery is filed long before they filed their motion. At the end of the day, we have them testifying very specifically as to what his damages are. Now, apparently you don't. We have testifying that the conventions were canceled. We have testifying that there were contracts. At this stage of the game, according to the Khan case, the court is required to assume all these things to be true. If all those things are true, we've got the plaintiff having serious damage. We got the conventions that had contracts. On top of that, you have this guy saying he interfered. So, are we not going to survive the motion because I can't get a convention owner to admit they canceled the convention? And the court says maybe yes. Yeah. Well, I submit that's not the appropriate standard, Your Honor. I don't know. It sounds kind of appropriate from where I'm sitting. I'm sorry, counselor, but, I'm a disinterested person too. And I have to say, so far, it seems to me that the court's getting it about right. I don't have any major issues so far. What else do you have? Well, I've got about 300 defamatory tweets. Opposing counsel has an interesting argument. The gripe we didn't include all the tweets, but then turned around and griped we include too many. So I'm not sure what the point is. No, and I've ruled all those tweets are there. That's why I've not ruled on defamation. Oh, I'm sorry. You're talking strictly about tortious interference. Keep up with what's going down. Okay? Please keep track of what stage of the lawsuit you're in. That would be helpful. Maybe write a note to yourself. Know what you're talking about. Literally, what is the subject at hand? Do you have any response to the tortious interference? The Khan case. Well, both real because they haven't ruled on it. I'll do that later. But tortious interference with toy. Now that this guy is saying all these contracts have handshakes, so there's a couple of arguments. One, you have to prove the terms of the contract. You can't just say I have a contract. Two, you have to prove what the damage was. Three, you still have a causation problem. The Khan case is exactly the question the court asked, which is why you didn't get an affidavit. And Khan even talks about proximity doesn't mean causation. Just because a statement was heard on a day and terminated doesn't mean it was caused. Yeah, fair enough. Proximity isn't necessarily causation. Yeah, and that's one of the reasons you'd want the statement from the guy, even if you weren't legally required to have it, because you want to know, hey, was it in fact the reason you did it? That would be helpful. As the court pointed out, everyone was writing about this in this time frame. So to say Mr. Toy's tweet means something, he had reason the convention terminated is kind of ludicrous, but more to the point, they're the ones that pled the specific conventions. They say Toy tweeted on these days and the convention's terminated. They're the ones who made evidence that's a good faith basis. Court. Let me ask you this then. Are you claiming Toy actually reached out to these conventions to interfere with the contract? Are you saying the statements they made on the internet was inference? I'm saying that he actually contacted them to interfere. Okay, please, for the love of God, let that be a true statement. Please, for the love of God, not take this back in the next 3 pages. I'm begging you. I'm begging you, please. Mr. Beard says, I'm saying he actually contacted them to interfere. Let's find out if that's true. The court, okay. The stuff he said on the internet is defamatory. Okay, then show me the evidence he contacted any of these people. Okay, as I said, he contacted, we know he contacted it. Okay, that was the existing contract. Okay, and Your Honor, I'm being asked to provide proof we're in a prima facie environment. You just said you had it. What's the problem? Look, if I walk up to you and try to steal the money out of your pocket and you catch me, all right, then later I'm in the room hovering in the background, money disappears from your pocket. It's a rational inference I probably took the money. It may not be the only explanation, may not be the most reasonable explanation, but it's rational. That's what we're talking about here. We got this guy. Two people overtly attempted to interfere with the contract. And legally speaking, at this stage of the case, to establish it, because testimony, in addition, we have the text messages, but you don't have any evidence that he called any of the people. No, I'm drawing a rational inference. Wow. So what did that take, guys? 2 pages? What did that take 2 pages for him to directly contradict himself? Let's go back up and just read it again so we can all admire it together. Court says, let me ask you this then. Are you claiming Toy actually reached out to these convention people? Mr. Beard says, I'm saying he actually contacted them to interfere. Oh my God. And then in 119, he says, no, I'm drawing a rational inference. Wow. The court, anyone could have called them. Agreed, but we know they did. No, you don't. No, you don't. You don't know if he called any of the people. No, I'm sorry, rephrase. We know they called at least one. If they called one, it's rational. It's rational if they called others. I think you need some evidence. So both are dismissed. The court is doing nothing wrong here, guys. Okay? The court is doing nothing wrong here. Mr. Beard and Vic just don't have the kind of evidence they need. They don't have it. They don't have evidence of proof of a conspiracy. They didn't bring in the discord for reasons passing my understanding, which might have helped with the conspiracy. Apparently not on the record. They had the statement from the one guy saying, yeah, he tortiously interfered, but it doesn't matter because we got a contract again from that guy and we said we weren't damaged. And all these other people, we have so many contracts. Which ones, the court say? So many of them. And they interfered with them. Really? They interfered? Yes, they did. How they interfered? Well, we're just drawing rational inferences. Oh my God. I'm feeling it all the way over here. Okay, the court says, I think you need some evidence. So both are dismissed. Okay, Funimation. Is that a question for me or, Your Honor, did you rule on defamation? I did not rule on defamation for Raul Toy, and I may not do that today. Okay, I need to read some of this stuff. Okay, Mr. Villani, may I begin? You may. I do. Hold on. It's my understanding Funimation has 2 tweets. Yes, that is step 1. I want to first confirm, as the court has done with other motions filed about the defendant, that we're talking about. We're talking about the 2 tweets that are published. So see, he's clarifying. He wants to be clear. What are we talking about? Is this what we're talking about? He's clarifying. This is good. The court, it didn't really say much other than letting him go. I didn't understand. He wants to continue, finish the season, then let go. Mr. Valenti, I understand well. The answer to your question is, I don't know. Okay. I didn't understand by reading whether he was able to continue with the season or whether he was let go immediately. Mr. Valenti, I read that as saying he was let go immediately, recast, and replaced. The court, okay. Mr. Valenti, but so are these 2 communications we're talking about. Obviously, I did confirm in the plaintiff's deposition that they were the only Funimation statements he's suing about, and this is an excerpt from the testimony. Let me go through the parts we've already covered and get to the meat of the argument. With respect to the defamation, Your Honor, there are particular elements we've already talked about. At the outset, it's fair to say the statement about Vic in the first tweet of February is a truthful statement. An update on the situation he does not deny, nor can he deny, because he pleads it in the first amended petition, was that there was an investigation and he was recast and he told Funimation he'll not be engaged in future productions. And I commented on this in my prior law stream. I said that this statement didn't strike me as defamatory. It's a truthful statement. It's at best some sort of invasion of privacy. But industry, this kind of industry routinely gives this kind of things. It's not unusual to read in trade papers like actor X was hired, or X or Y was fired, or director Z was whatever. So like simply saying this guy was dismissed, we hired a different guy, whatever, that's not defamatory. It might be invasion of privacy, but it's probably routine. So that's not a problem. And I said that in my earlier stream. I think he testified in the deposition there's nothing untruthful about the tweet. Yeah. The second tweet is another true statement. The part of the core mission is to celebrate diversity in the anime community. Share love for all. We do not condone any behavior. Okay, that one I'm going to disagree with the counsel on. In context, I think that qualifies as a statement of fact against Vic. Stating we do not condone any kind of harassment or threatening behavior being directed at anyone. The statement on its surface is not directed at Vic, but in the context of the overall context, it clearly leads to an implication about Vic. So to my mind, that is a factual statement that he harassed and threatened. So let's see what their counsel says. That particular tweet, Your Honor, does not mention Vic, and his truthful statement about the same time is tweeted about him being recast. I don't agree with that conclusion. For that reason, he hasn't met the first element of the defamation claim to show an untruthful statement was made. Your Honor, the case law was cited. Some case out of Austin qualifies a defamatory statement should be derogatory, degrading, somewhat shocking, and contains elements of disgrace, which incidentally, I think that one does. There's nothing about the February 11th set of tweets that does that. In fact, Your Honor, I'm going to put those tweets in context. We submit evidence to the court, including this affidavit, which is part of our motion, which talks about what was Funimation's mindset when it published the tweets. For purposes, their defamation by implication argument, because it would be defamation by implication. That I agree with. It is an implied thing. It's not on the surface, it's implied. So it is defamation by implication. If a court finds as a matter of law there is a possibility of some defamation by implication in her, what we put before the court is evidence that we did not act with malice in making his word defamation. That's a fair counter. That's a fair counter. Particularly because based on all we're saying is that Funimation did this huge investigation and they interviewed a whole bunch of people. So they might very well have evidence that supports, at least from their point of view, that this is a reasonable thing. And because he's a limited purpose public figure, yeah, I would say there's probably not malice. So I think that's probably correct. The malice standard has been talked about. It's not the attitude towards it. It's the focus on the attitude. It's not the attitude towards the plaintiff. It's the focus on the truth, the attitude towards truth. Yes, the malice is towards truth, not to the person. That's a good way of putting it. Yeah, the malice is towards the truth, not to the person. We didn't engage in any part in it. The plaintiff has not put on any evidence before the court of actual malice. There's no evidence in the record of our state of mind. Well, it doesn't need to be, but whatever. He didn't take a deposition. Really? That seems sloppy. He didn't engage in any discovery, no evidence whatsoever. So in terms of playing the field for actual malice inquiry on Funimation, assuming the court credits their defamation by implication, there's no evidence other than what Funimation puts the record in. First of all, there's no malice as to the first tweet because it's true. Yeah, I think that's right. With respect to the second tweet, we put evidence in the record of the company's state of mind. The purpose of the additional tweet was to respond to continuous heated back and forth among anime fans and was an effort to encourage stability. Okay, it's a reasonable line of argument. It's a good line of argument. The facts aren't great for animation. It's a good response by their attorney. Okay, sit down real quick. Are those really tweets that you're all saying are defamation from them? Yes, but there's a lot of context. Okay, let me talk real quick. Sorry, let's talk. Yeah. Let them talk for a second because I think the company has a right to do a press release if they did and say he didn't do anything wrong. Well, let me address that, Your Honor. Okay, was defamatory about a press release and letting someone go? Good question. To answer your question, I'm going to have to back up a little bit. Not an encouraging response. The court, they have to be statements that you're suing defamation for. What statement are you suing for? We're suing for the implied statement that they said our investigation found the plaintiff guilty of sexual misconduct, including sexual conduct, because it was being talked about at the time. I didn't see that. I didn't see that statement. That's what I'm looking for. Right. If I could back up with one point that's relevant to the whole discussion, he was terminated 11 or 12 days before they issued the statement. It's already known in the communication that he'd been terminated. They didn't have to say a word. But there's no reason they can't either. Yeah, correct. There is no reason they can't either. And it's not defamatory because it's true. I agree, but there's a thing, Your Honor. Oh my God, he loves the analogies. He loves the analogies. The analogies aren't going to help you, my friend, because yeah, they're just not working. But let's read another analogy. If I go across the street and I say I walked in my neighbor's house, I saw him interacting with my kids, I left, and I call CPS because I don't support child abuse. Each of those statements could be true, and the four taken together could be defamatory. I agree with the sentiments, but whatever. The problem Funimation has gotten into is they came out and said, we conducted an investigation, then immediately, and we're terminating him. In the context of the allegations, they immediately said, and we don't condone harassment. I agree with Mr. Beard here on that point. I think the statement is an implied fact against Vic. I think that's correct. Then Rial comes in and says, after some questioning, Rial comes in and says, well, I give you the exact quotes in Funimation motion. Rial replies, there are dozens and dozens. Let me get this. Anyway, Rial comes in and basically says, there's a huge investigation, dozens of women participated, and he was found guilty. Funimation never said a word, never said a single, no, wait a minute, that's not what we meant to imply. That is not accurate. Oh, counselor, might want to get it straight. Well, hold on. I mean, we're dealing with vicarious liability or I'm dealing with Funimation's implied defamatory statement. Okay, they make a statement that's true. They made a statement that's true. Correct, but the implied meaning is defamatory. I mean, they did conduct an investigation because Vic testified to that. They did terminate him. That's not a question. But the context of what's going on is that he's being accused of sexual assault. The thing is, they didn't need to do anything. Their studio simply said, let him go and be done. Then 11 days later, they came out and said, just to let everyone know. We let him go because we did an investigation. We don't condemn harassment. Now, in their affidavits, it's kind of interesting. Funimation in their affidavit, okay, Funimation in their affidavit, the produced affidavit says they're curiously non-specific about what they investigated. In their affidavits, Mika says the investigation was conducted. Denbrow, who conducted the investigation, says the investigation was conducted and he found and thought was inappropriate conduct. They didn't tweet that out. They didn't say, we found he engaged in inappropriate conduct. The trail of messages, which you could see in Funimation's own pleading, everyone that responded to Funimation's tweet as saying he committed sexual assault in their investigation, and they found out. What they actually investigated, according to the people and according to follow-up, is the aided jelly bean at the convention. I mean, I read that, I know. Well, he was accused of kissing a Funimation employee years ago one time, which he claims was consensual and never reproduced it otherwise. He's accused of making a pass at a fan. I don't know why we're talking about this. It's off point. It's not good for your case. You should be focusing on the defamatory implication. I don't know why you're talking about this. It's not helpful. The court, they may have made a bad decision, in firing him. There may have been wrongful termination of contract or wrongful termination of employee. Actually, Your Honor, I don't think so. Texas is an at-will state. Even if you really think that, you shouldn't be saying it. The court just gave you a potential freebie. Even if you really think you don't have it, you really shouldn't. There's no reason to correct the court. That's just bad form. The court, okay, that's my point, is they have a right to make decisions, and they made decisions they posted about. There's nothing false. Notice the implication. The court says, I know, you said that. I heard you. Mr. Beard, I said I called CPS. I heard you. I heard that. Mr. Beard, but I'm wrong about that, Your Honor. It's implied defamation. We keep hearing about context. This is context. This is a man being bombarded with accusations of sexual assault, bombarded. In the middle of all this, totally unnecessary, Funimation comes out and says, we conducted an investigation, we fired him, and we don't condone harassment. Mr. Beard, I think his point is correct, but the malice thing is going to be a problem for their side. But I think he's correct in terms of the implied defamation. Mr. Beard continues. Not only that, Funimation never bothered to say what they said in their pleadings. The pleadings say, we never heard of Monica Rial. She's an independent contractor. We didn't intend to imply she was a sexual predator. I don't know why you're talking about that. It's not relevant. Mr. Valini said it here. They said it all throughout their pleadings, but not one time did they tweet out the clarification. So we're defaming in a public forum like that. You can refuse for 7 months to clarify. No, that's not what we meant. What we actually said is your legal case. You're actually saying in the affidavits, you're saying in the pleadings, I'm sorry, we believe we meet the prima facie proof. Other curious thing is, Your Honor, there's not a digression. This will tie into the conspiracy theme, but since we're talking about it, I won't. All right. So Rial says she reported the jelly bean incident, and then they did an incident investigation, got fired. A few days later, she said, I was also assaulted. Vic says, no, I wasn't asked about that, provides an email, so the evidence would appear that she didn't report actual violent sexual assault, but did report the jelly bean incident. The court, what if she lied to Funimation, but they just believed her? Can they not rely on that? Your Honor, yeah, they could do what Rooster Teeth did, that one, yes. The other studio said, we investigated Vic and we're done with him. You'll notice they're not a party. They didn't come out and say publicly, we conducted an investigation, we terminate him. That's a huge difference. But if I could get back to my point about Rial, this is important, trust me. Okay, Mr. Beard, I trust you. Let's press on. Funimation in their pleadings has been extremely vague about what was investigated, and the reason is obvious. The reason is obvious. They're not going to tell what they specifically investigated, because if they did, it would show Rial to be a liar because they did not investigate the 2007 event because it hadn't been reported. This also goes to evidence of conspiracy. Why do they care about the voice actor they've never heard about? So I'll get back to defamation, but a tangent was necessary. If they said reasonable inference from the investigation was we fired him, we don't support him, they don't condone harassment. Okay, so it seems like you have a breach of contract. Actually, Your Honor, I don't think we do. Why are you correcting the court? Just don't do that. Okay, so what damages does he have from firing? What damages does he have? We're not complaining of the firing. We're complaining of the defamation. Right. But it seems like that would be the damage. No, that's not right. Oh, I get your point. Well, what's funny here is he doesn't make much money working for Funimation. He makes money at the conventions. So then is his tortious interference to defamation? Well, the defamation is what caused the conventions to cancel him. Okay. But the statements they made to the internet were defamatory because they caused a tortious interference with the existing contract. I think it's a rational inference. There are no specific damages coming from the defamation that would be tortious interference part. Mr. Beard, well, no, I say Vic testifies he had conventions. They cancel left and right, the court, because of statements. Yes, okay, so he was told, I'm sorry, Your Honor, I don't mean to interrupt. Don't interrupt the court, just FYI. I think there's damages for defamation, which I don't. I think that there is damages for defamation, which I don't think he has any, but defamation could cause him to lose a contract. I agree with that. That could happen. Cause people to prevent from working for him in the future. I think those two causes of action tortiously interfered with. Well, Your Honor, if the implied defamation occurred, it's defamation per se. Damages are presumed. It's even more so, he can't really, if the defamatory meaning we've attached in our investigation found him guilty of sexual misconduct, blah, 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 we also believe they implied guilt because of that. Under the con case, Vic denies all those things and stage of the game, his denial is deemed to be accurate. The deal is very simple. Several months went by, the folks left the tweet without clarifying, oh no, we didn't mean that. The reason they didn't clarify is obvious. It was their termination of him that gave him the impetus. They got killed by two things, okay? Vic's first actors who worked with him accused him of these things. Funimation, who employed him, did an investigation, implied it was for sexual assault. Well, here's a good point too. Vic had worked at Funimation 15 years, so losing that contact damaged him. The court, well, write down a number for me. Mr. Beard, I don't have to because defamation per se. Damages are presumed. The court, okay. I mean, they are. He's being accused of sexual assault. That's defamation per se. I don't, off the top of my head, know what his earnings were for Funimation each year. They're probably on a scale of $30,000 to $40,000 a year, but that's speculation on my part. How do you not know what your client earned? There's no way at this stage of the case, there's no way for us to be able to say what his economic damages are. How is civil conspiracy? Well, some of the facts I say here point to civil conspiracy. This curious protectiveness over Monica Real, despite allegations she's just some independent contractor. The court. I mean, if you're running a company and had a bunch of people come up to you, several people come up and say, this guy's sexually harassing me and assaulting me, I don't think it's in the company's interest to hold on, investigate, and then they fire him. It's not a conspiracy with the accusers. They're just trying to do what's good for the corporation. But it's just trying to say that anyone can come in and make an accusation with the conspiracy is Funimation when they're two distinct entities. Well, I don't think I'm saying that, Your Honor. Okay, should I just dismiss that one or should I keep going? Ooh. What I'm saying is, I think, what's your conspiracy with then? It's Real and Funimation together. Okay, that's what I was just saying. The answer is Real. And yes, she goes to get this stuff, right? And they did fire him, right? Where's the conspiracy? They came out, okay, number one, she mischaracterized the investigation involving dozens. Let's say she lied. She may have lied to them. She lied in response to the tweet, Your Honor. She never. The problem is the intent. It has to be from Funimation that they want to fire him before she comes there. And they get together and plan a way to fire him. And that's not what happened. What happened is she came to Funimation and told me these things and they fired him. They didn't plan to do it. Fair. Mr. Beard, is the court, did I make it clear that I fired him 11 days before they announced the tweet? Okay, all right. A defamatory tweet itself is a huge cause for cancellations. We're on a conspiracy, and I'm asking who the conspirators with. Monica Real and Funimation. Okay, but just because someone comes in and makes a complaint doesn't make it a conspiracy. It's a process you go through for HR. It's another fact I need to get to. Thank you. After termination, Monica Real exchanged 17 emails with Funimation. Again, this is supposed to be some person they have no interest in. She's just an independent contractor, and yet she testified at the deposition we're close friends with some guy who is one of the executives of Funimation. It's an awful lot back and forth, griping about Vic. You're talking about afterwards? You're talking about the planning afterwards? The conspiracy started before that. Well, very well could be. You have to use an inference. You've got to figure this stuff out. I'm serious. If they're going to have a conspiracy to get him fired, if that's what the conspiracy is, to get him fired from Funimation, is that the conspiracy? Mr. Beard, no, not just that. Is that one of them? Yes, that's one of them. Yet you have no evidence prior to him being fired that they had a plan. Well, we have circumstantial evidence, which is permissible. Okay, the emails and stuff you're talking about happened afterwards. Yes, here's the thing. We only knew what they turned over to us. Again, I want to point out to this court, we have a motion to compel on file. We only have the emails turned over to us, and they started after he got fired. So, I don't know. Vicarious liability. You think because these people are in the course of scope of business at the time. I think it's a rational inference. Okay. Number one, they claim. Funimation claims she's an independent contractor. They've never approved her employment contract. Excuse me. Actually, that's not true. It's been a supplemental affidavit. Mr. Beard, I'm sorry. I was talking strictly about the motion. I'll correct the statement. But of course, all that was filed after the deadline, we think it should be stricken. So the court takes evidence in, then my statement is not correct. But the court, holds it. Then the court, then I can let you lie. Is that how it works? Okay, guys. Well, Game over, guys. It's time to go home. It's over. Thank you for joining the Internet Law Review. Oh, Lord. Mr. Beard, no. The court, well, I want the correct answer. Your Honor, I actually don't know. I'm taking John's word for it. I don't think he'd lie about it. Mr. Beard, if he says it's in there, I believe him. I was focused on the motion to dismiss, not the extra evidence. You don't have any evidence that they're independent contractors, do you? Do you have any evidence they aren't independent contractors? Depends on what the court is allowed to supplement. As the motion stands, no. It's just fine. Just say no. And Vic was an independent contractor, right? Oh my God. Your Honor, whether someone's an independent contractor is a question of law. I can't answer that question. Oh my God. Yes, you can. The court. Okay, don't answer it then. Keep going as far as the agent. Mr. Beard. All right. So she's an employee then. Well, they're joined together, obviously, by what we just talked about, the conspiracy. Well, she's not an employee. She's not an employee, then vicarious liability does not attach. Okay, I mean, you have to be an employee to be part of the vicarious liability. And I need to figure this out as a matter of law, right? Well, as a series of fact tests applied by whatever, I don't care. Was your client an employee? I kind of think he was. Wow, that's super helpful. Thank you for having a firm position on that one about your own client. At will, at Yale, well, I think he was an employee because his contracts, my understanding, his contracts roll over automatically. Funimation exercised a data control and forth and blah, whatever. They signed a contract. For the period of time they worked, they didn't have to be renewed. Okay, that sounds like a contract. What else? Employees can have contracts. Sure they can. What else? That's vicarious liability. Okay. We have no evidence she's not an employee. She did work for them and, they all acted in concert. Rational inference. Okay. Would you like to respond to any of that? May I? Yes. That's why I asked. The court, I think, is being a little snippy at this point. The court has lost its patience. Mr. Volney, Your Honor, there is evidence in the record about the business relationship between Funimation. You can sit down. He's saying this because he automatically stood up, and they had previously talked about being able to sit down. So he's not being rude in that statement. He's just making it as a statement. So anyways, between Funimation, Miss Rial, and Miss Marachi, and the evidence, the testimony contained in the affidavit, she talks about the business relationship that confirms they're contractors. They are in order with denied objections. So on the record, there's no possibility of vicarious liability. That's the question you just asked. I point to the court to this deposition. You weren't like a W-2 employee that provide benefits. Yes, sir. For your voice acting. Yes, sir. So it's not really disputed. I think you can infer a lot of things, but those inferences have to be rational. The court says, okay. So he's not an employee, not within the course and scope. So that's my point. Well, hold on. Pardon. So he thinks Funimation and Rial cooked up a conspiracy because she reported something to them, which may have been true or false. I don't know. But she reported that Funimation acted. Ms. Fellini, there's no negligence claim relating to the bad investigation. That's a very fair point. We did an investigation, we fired and terminated him. He agreed that it occurred, so our tweets about it are truthful. He's saying you conspired with her, like y'all had a plan with Rial. Mr. Valeni, so that would be about his burden to produce evidence to the court about it, and he didn't do that, and timing just doesn't make sense. Leaving aside the evidentiary problem and the facts there's not a pleading to support, I think it responds to what he's talking about, the court talked about. Just one last thing. I don't think there's a cause of action for defamation by implication by omission. Okay, interesting. So you can in general defame someone by omission. I can't really give a good example off the top of my head, but like, let me say like you're praising a whole bunch of people for really specific stuff, and like one of them you don't praise it for, and you then praise like everyone else for the same specific stuff. So the omission implies that they don't have that specific thing, and that could be a false statement if they do. So it could be defamation by implication by omission. He's saying you can't do both at the same time. I don't know if you can or not. Interesting idea. Can you defame someone by omission and by implication at the same time? I don't know. Good argument though. We did investigate him. We did terminate him. We do celebrate the anime community. But I think your tweet, your company tweet found out we had a bunch of rapists working for us. Tweet 2, we fired Vic. I mean, you could be a defamation by implication there. So even if you didn't say it, that's what they're trying to say. Mr. Valeni says there's case law for implication. The court says, yes, I agree, there is. I say two things. One is sexual assault or rapist doesn't occur in the second tweet. So I think it's not as clear as the court's example. No, it's not. But then second, the more important is in the context that people say things about public figures like Vic, in order to them prove defamation, he's got to prove actual malice. In order to prove defamation, you got to prove actual malice, which is the legal standard from New York versus Sullivan, which it certainly is, which we all learned about in law school. Yes, we did. Very, very famous case. He doesn't have any evidence of Funimation's state of mind in issuing those tweets, and the only evidence before the court to the contrary is Funimation was responding. So also I have with respect to the last part. I say with respect to tortious interference, I don't think the analysis is any different than that with Funimation opposed to the others. Mr. Beard, may I? Sure. Okay, number one, Vic has not been established as an expert on independent contractors. The court, I don't think he is either. Mr. Beard, and the same is true for that matter of Funimation's self-serving statements, though he's an independent contractor. Where's the proof? I mean, it could have attached an employment agreement. Lord have mercy. And Your Honor, I really think the court needs to find out in favor of fact those motions need to stand there. They don't get to keep adding evidence out after the deadline. The court says I let you. Burn. Yes, it is a Clemson banner on my wall. I'm a proud Clemson graduate, as you can tell from my orange watch as well. This is not a Clemson branded watch, but this is a orange Seiko. I am a Clemson grad of 2004. So go Tigers. Carolina all the way. Well, how's Carolina doing in their football season relative to Clemson? Remind me, how many national championships have they won recently? It's so hard to keep track of all the national championships that Carolina has won. Yeah. Coastal's cool. I like Coastal. Coastal Carolina's a cool school. Let's see. Mr. Beard, Vic is not an expert on independent contractors, but here's the thing. I mean, even if they are employed, it doesn't necessarily mean their contract is imputed on the employer. I mean, not all your conduct would be imputed on your employer anyway, so I don't know if it's that big a deal. We'll just say that you have to have an employee for vicarious liability. I understand that. But of course, could still find their actions were not within the scope of employment, and so it doesn't matter. You could find that way, Your Honor, yes. I don't know if doing voice acting requires you to post stuff on the internet that's defamatory. That's a fair point. It might not be in the scope of their employment. Very fair. It's part of Funimation's contract that she's supposed to post defamatory stuff or something she would do. Well, Funimation is actively defending the guy and she's posting out, she's an employee. I think it's rational inference that she's acting in the scope of the employment. Not really, but thanks for playing. We don't condone any kind of harassment behavior, of course, made that point. Yeah, I mean, I understand that, but their recourse is to fire her. I mean, if she's doing something wrong, they should fire her, and the complaint should be made by her. But what you're saying is that anything she does outside of voice acting, they're on the hook for. Yes, outside the course of scope of employment. I can see that point. Okay. So you're saying part of her employment is intentional toward her publishing stuff on the internet. Monko's deposition says she was treating other promotional work as part of her job. That's a very fair counter. That's a very, very fair counter. If she's using it for business purposes, then yeah, that probably counts. Mr. Beer now tweeting about Vic. I don't know how you want to slice that. The court. I bet it doesn't say about Vic in there. I bet it doesn't have to be either. Ooh, that's a little aggressive. The court gets to be snarky. You don't get to be snarky back to the court. That's just how it goes. I think we're making a big deal over the employment over independent contractor. I don't think it matters one way or another, but I don't think she was acting in the scope of the employment. But Your Honor, is a rational inference that could have been made. No, you made a lot of things that are rational inferences, and they're not. I mean, I've got to get it, Your Honor. Yes. That far as Mr. Valenti's statements are that we're trying to do defamation by omission, that's not what I've offered evidence for. The court, no, I don't think so. I mean, your argument against them is defamation by implication. Yeah, that's what it is. The omission goes to conspiracy, the allowing her statements, not clarifying they participated in the conspiracy. Vic has alleged in the past he's never had one single convention, not ever, canceled him until this year. The big difference was people who worked with him, companies he worked with. We didn't sue Rooster Teeth because all Rooster Teeth said was they terminated him. And all Funimation said initially, on the 26th of January, they said they terminated him. They stopped. If they had stopped there, we wouldn't be in the lawsuit. It was that extra step. That's right. I think you're right on this point. So it'll be interesting to see what the court says, because I think you're right on this point. Now, as to the malice part, that might be a problem. And as to the liability to the employer, I think it's a problem. But I think the statement on its face is a statement of fact, and I think it is implication. I agree with that. As far as Mr. Valenti's other statements are, there's just no statement that are true, but we've gone over that ground. You made two completely true statements together that are defamatory. That's defamatory by implication. I agree. All right. Okay, I'm dismissing tortious interference with existing contracts, tortious interference with constructive business relationships, civil conspiracy, and vicarious liability. I'm going to rule in defamation for the Funimation Productions, defamation for Monica, and civil conspiracy. I rule in defamation of civil toy and civil conspiracy. So that's where we are. And I have 30 days to do something, or they're overruled. Yes, and we're done. Okay, fair enough. So, seems right. I have no major problems with this. Mr. Beard made, it seems like, some errors along the way, not including the Discord stuff seems an error, not getting some statements and emails from the other convention partners. I mean, just emails from them basically saying, did you fire this guy because of this? Get him on the phone and ask him. I mean, you don't necessarily have to, it's just anything to like help get you along before you file suit, because you're in control of timing. So that seems like there were some mistakes there in terms of the practice. yeah, and the fact like he made these like misstatements and he's saying it's not paying attention, he should pay attention. So I think the defamation by implication issue is still alive. They dismissed the respondent superior because of the contractor status. So it looks like she's just on the hook by herself. If they can get Funimation for the omission by not correcting it, doubtful. But then you still have the big question of the malice. Is it malicious? Probably not, because they did this thorough investigation. So yeah, I think best guess. I think all these causes of actions are getting dismissed. That'd be my best guess right now from where I'm sitting. I think it's all getting dismissed. In terms of the anti-slap remedies, yeah, I don't think it's anti-slap issue. I think it's a valid complaint. I just don't think there's any evidence. So best prediction from me, the anti-slap motion fails. The case gets dismissed for failure to state a claim because there's just not enough evidence, and everyone moves on with their lives. That's the best prediction I have from where we're sitting at this point, on the basis of everything. Because you just didn't get what you needed to show. The tortious interference stuff was actually really interesting, but you didn't get what you needed, either as a matter of practice or as a matter of law. You really needed the statements from the people saying why they fired you and why they didn't hire you. You needed that. All you're doing is speculating. You're saying, well, look, a bunch of people said all these tweets, and all these people then said, we're not going to work with you anymore. It must be because of the tweets. That's what we call speculation. It's enough to get you through the door, but not enough to get you home. You have to like say, hey guys, why didn't you hire me? We had this relationship. What's going on? And get them under oath, get a deposition, get an email, get something. So I think all this stuff is going away. I think it's going to be dismissed with prejudice and stuff. Hawaiian Hoth says the defense didn't give evidence they were supposed to. If that's true, if there was a discovery violation, then the court can deal with that too. I mean, they didn't really talk about that. The Mr. Beard said that there's discovery motions pending. They didn't really talk about that, so I don't know like if there's a discovery violation or not. But as I was pointing out, you don't necessarily need discovery. In terms of getting statements from these convention people, you could have just sent them an email and got an email back. I mean, you don't necessarily need discovery. I mean, you could have tried before you filed the lawsuit, so I think there were some missteps there. But if there's a discovery violation, if they haven't given discovery they need to, then that would be fine. And maybe that's another reason to keep this case alive. But from where I'm sitting right now, best case is it's going to be dismissed because there's just not enough evidence to go forward. Demon Wolf says they fired him over a Jelly Bean story in a tweet. Well, assuming that they can fire him for cause, they can fire him for any reason they like. So it's not a breach of contract. It would be an issue of defamation, and we were just covering that. So, yeah, I think it's a problem. So, yeah. What if now the conventions replied or didn't reply to asking? Well, they could have. It doesn't seem like he tried because they asked about that, and he didn't say, well, we sent out these inquiries and we couldn't get any response back. He didn't say like we tried to. He didn't really seem like he did those things. I mean, obviously, you try something, and if it doesn't work, you have to try something else. So if you send out emails and phone calls, and they refuse to send you back and refuse to turn your phone calls, then you have to try something else. Then you have to give them a subpoena. You have to do depositions. There's like ways to do that. And if there's a discovery violation, then there's a discovery violation. But it seems like all the I's weren't dotted. It seems like some of these weren't done in advance when they probably could have been. I mean, it would have been helpful to get some statements from some people, and maybe some of the convention people who would have responded would have said, yeah, we talked about among other convention partners, and they said the same thing. So like even the hearsay statement would be enough to like get you through the door of a rational basis to like do further discovery to find something that's admissible. So, hey, Hiawatha and Hawthorne, no problem. Where you say, I'm trying to understand. I'm not a lawyer. I'm not trying to be hard on you. So don't mistake my tone for being difficult. I'm trying to answer your question as best I can. I love questions. I love teaching, and so I'm trying to be nice, Robert. You know, this is a legal education channel, so everyone's trying to learn here, and so you know, be nice to one another and give people a little bit of slack here. I see that. I see that now. That was in response to them. You know, everyone's trying to learn, and people get the law confused all the time. You know, things drive me crazy. in law. I was seeing something the other day, and I was responding to something, and like everyone was yelling on Reddit. I was responding to someone. I was getting massively downvoted, and everyone was yelling at me because I was saying something they didn't want to hear. I mean, I know I was right, but the law is. But Easy07 says, you think I did a fair and good breakdown? Thanks. I mean, I'm trying to be fair to both sides, and just try to read it and give my best analysis of what I think on the law. And yeah, I think the part Vic really screwed himself on the limited purpose public figure. The part that really screwed him was the part where he went onto his fan page blog and told his fans to go forth into the world and help rebut all the rumors and stuff. Like right up until that point, I was like, I don't know, because I'm hesitant to pull that trigger. And then when you're like, oh, I'm taking active effort to get people to create a public forum. I'm not creating a public forum because I'm asking people, members of the public, to create the forum for me. I was like, oh, that's the point of this analysis where things really go down the tubes. So like the Twitter followers, the big fandoms, people want signatures. I'm like, I don't know if that's enough for public figure. I don't know if it's enough. It was like, go forth, my pretties, go forth. I was like, ooh, that's bad. That's not going to fly. That's going to be a problem. What about Monica telling people to contact the workplace of people who don't agree with her? Well, those people might have a claim of action against Monica. Like, if what you're saying is like other people are disagreeing with Monica and Monica's trying to dox them and get them fired and stuff, those people would have causes of actions against Monica for tortious interference, for damaged reputation, for a whole bunch of things. So like Monica going after people, those people have causes of action. So that may very well be a tort there too. So yeah. Let me see if I missed any other major comments. Again, wanted to thank Robert Sass for his $2 super chat. Really, really appreciate it. I really, really appreciate the encouragement. I really thank you a lot for that. Let's see. Fangi says it's been very educational. Thanks. I try really hard. Is context more relevant for actual judgment? It's relevant both ways. Context helps you to understand what's going on. Let's see. Yeah. Vic having 14-year-olds in his hotel room came out false long before February 6th. I mean, I don't know whether it's false or true or not. I was just reading the deposition, so we read it together. I mean, I obviously have no knowledge as to whether that's true or not. Let's see. Defamation in Denmark, easy proof? Probably. In Germany, if I call someone something in court, defamation? Probably in the US too, for that matter. The litigation privilege gets you a long way away from that too. Let's see. It's different in court in Japan than here. If you're talking about Ace Attorney, man, I don't know what court system that's meant to represent. That's definitely not Japan. I'm sure it's not. Yeah, that's too much. Let's see what else. Yeah, that's it. So I hope this was helpful. I hope you liked it. I enjoyed it. This has been 2.5 hours of covering this. And tomorrow we're going to do another live stream over a whole bunch of other cases, because I've got a whole bunch of stuff listed in the docket. But this case is interesting, and we'll see what the judge says in terms of this. We'll see if the judge dismisses everything, and if what he says is because of the public figure status, which is my best guess. Hawaiian Hothy says, what about Jamie saying you can't be neutral and that you're sick voyeur who shows people pain if you don't choose a side? Well, I oppose that. So does that mean I'm on a side? I don't know. I mean, I don't have enough information to choose a side. I'm too far removed from this. I don't have any firsthand information. I don't run in these circles. I don't know any of these people. I'm basing it off filings and basing it off records and basing it off evidence. But like a good attorney, I'm basing it off evidence. And looking at the evidence, I'm like, well, there's some problems here. The evidence seems a little thin in my mind. You could have gotten some of this evidence before you filed suit, maybe. Maybe you should have tried to do that. But now I think you have a problem. So, yeah, I think this is getting dismissed. Got to wait 30 days. The appeals are all being mentioned. Yeah, I mean, sure. I have no problem that appeals are being mentioned. Maybe the judge made mistakes. Sure. That's what appeals are for. It's correct legal mistakes. No problem. Um, I don't know why they're making a huge war. If you're not with them, you're against them. Yeah, I don't know why they're making a huge war. It might be like a Me Too thing. I think it's some of the backlash to Me Too, because there have been Me Too accusations that are true and Me Too accusations that are false, and I think it's some backlash to that, and that's to be expected. Mm. Very good stuff. I hope you enjoyed the microphone, the brand new microphone. Expensive microphone, so improving the audio quality. And next, maybe we'll improve the camera so you can see me other than webcam. But the Logitech's not too bad. I should be on stream tomorrow on Twitch, probably give or take 1 o'clock, whenever Leonard's done with his thing. Probably do a 3-hour stream tomorrow, so you can look forward to more law. Haven't really decided which stories I'm covering. I've got too many to cover as it is. But we'll see what the list looks like, and we'll pick stuff that I find to be interesting because it's my stream. And as always, I'm happy to take suggestions from you guys, so you can find me in Discord, tag me with stories you think are interesting, and if time allows, I'll be happy to cover it. So yeah, I think Robert has a good point. I think Vic might have had a good case when this first started. I think there were some missteps here, and I think his case has some major problems. Best prediction is it's going away. So yeah, not great times for Vic's lawyers. I think there were some missteps here along the way. And I'm not in this. I don't want to throw his lawyer too deeply under the bus either, because it's tough when you're in the trenches. It's much easier to be like, Monday morning quarterbacking. It's much easier to look back and say, well, these seem like errors. It's much harder in the moment. So I don't want to throw him too much under the bus. There might have been very legitimate reasons for things that he did and legitimate decisions he makes. So I'm not saying that I think Mr. Beard committed malpractice. I don't have enough information to reach that conclusion. Lawyers have to make a whole bunch of strategic and tactical decisions. The fact that I can, looking backwards, see like, well, this would have been good or this could have been good, it's a little bit unfair, because it's harder in the moment to do anything. It's harder in the moment than to criticize looking backwards. So I don't know whether or not Mr. Beard, what the quality is overall. I just know that at this point, it looks like this is going away. So due to missteps, perhaps those missteps were intentional. Perhaps they were intentional for good reasons, but we don't know enough to throw them under the bus. We just base things off the facts. I hope you're well. Look forward to talking to you guys on Discord some more. Could he fix it on appeal? Not if they dismiss it with prejudice. They don't. Depends how great. And at this point, the court seems pretty irritated. Because of like this second stuff and the problems with the notary stamp and all kinds of stuff. So if they dismiss with prejudice, it going bye-bye unless the Court of Appeals finds some sort of legal error. And I haven't found one yet, but there might be some stuff dealing with discovery that might be a legal error. Can you discuss new facts on appeal? No. No new facts on appeal. Appeal is just pure law. All appeal is law. All you want to know is law is on appeal. So all you do is the legal issues. And you say, did the court below make a legal mistake? And you say, well, I have new facts. And the Court of Appeals says, no, thanks for playing. You don't get to do that. So yeah. We don't know. We'll see. We'll see what happened. Did he rip off Vic? I don't know if he ripped off Vic or not. I don't want to draw those kinds of conclusions. All I can say is that at this point, it looks like it's getting dismissed. I don't want to unduly throw another attorney under the bus. I'm very cognizant of trial, the pressures of trial. I'm very cognizant that you have 100 things going on and you have a dozen decisions to make at any given time. And you have to make tactical and strategic calls. And sometimes they don't work out the way you think they will. And it's a difficult practice. It's artistic. Sometimes it goes wrong, and it's not because you made a mistake. Sometimes it just goes wrong because things didn't work. You made a strategic call, and things go the way they do. So, I don't know. I'm not going to go so far as to say he ripped off Vic. I'm not even going to go so far as to say he did a bad job. I don't have enough information to draw that kind of conclusion. All I know is that we are where we are, and the evidence is what it is. And it's like, well, it's not getting you where you need to be, and there's some problems. And he seemed a little bit disconnected. I believe my Twitch channel is Blackleaf31 on Twitch, so you can subscribe to me there. So yeah. So I don't know that his attorneys did a bad job. I'm not ready to reach that conclusion. I'm going to sign off before you guys keep asking me more questions and I keep talking. All right, guys. Love you. Cheers. Bye.